Yes. Hello, I beg to mention for listing, my lord. I beg to mention for listing, my lord, for on tomorrow, my lord. What happened, my lord? I am challenging the tender clause. I am challenging the tender clause, my lord. The tender will be that the last date of the tender is the 21st. So, my lord,
Why do you have to challenge? Why do you have to challenge on at the end of the time time period? Huh?
Meeting was held on 7th, my lord. And they have said that on 14 we will take the decision. No decision has been taken. We have submitted the representation. Till that, my lord, no action has been taken. That's why, my lord, we have come
Okay.
on tomorrow, my lord.
Made this solution. The lordship I beg to mention for listing of the writ petition in the admission column. Any date.
Next week, after that, I don't know, someday, give a date.
Made this. Item numbers 43 to 48 is a series, my lord. May I pray at 2 o'clock? Because it can be disposed of.
Okay,
The government is admitting to that.
2 o'clock.
May please, lordship, I pray for listing a matter for admission, lordship, on Wednesday. Matters regarding settlement, matters regarding fair price shop, lordship. And my license has been cancelled.
What?
Matters regarding fair price shop, lordship.
Huh? What shop?
Fair price shop.
Fair price.
And my license has been cancelled, showing me that I am dead.
You're dead.
Yes, lordship. Development.
Make me the Lord. My Lord, prayer for listing of a matter. My Lord,
New matter, old matter,
my Lord, old matter, my Lord.
give a date.
Oblige, Lord.
Item 1 for motion. May please, your lordship. But this application for violation of the order.
Okay, right, third, Mr. A.K. Sharma, learned counsel for the petitioner who submits that the order dated 19/10/23 passed in WPC 6/2/63 of 2023 has not been complied with. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent number 2. Sole respondent by registered post with AD within 3 days. This is the matter after 4 weeks. This is the matter after 5 weeks.
Obliged. Item 2. May please, your lordship. What is the content application, my lord?
You know, waited for a bit of time. Order was passed in April. Right, heard, Mr.
K.N. Sharma.
For whom? Your name is not here.
Well, I am for the petition, my lord.
But your name is not here in the call list.
Then I am appealing on behalf of
On behalf of Mr.
S. Samaria.
S. Chamaria, okay. Actually, A. Sharma is here.
Yeah.
But you have not signed.
Hello?
Your signature is not here in the Vakalatnama.
I am appealing on behalf of Mr. My.
Okay, you could have signed the Vakalatnama, that was okay. Right, heard Mr. A. Sharma, learned counsel, appearing on behalf of Mr. S. Chamaria for the petitioner, who submits that the order dated 8/4/24 passed in WPC 2416 of 22 has not been complied with. Issue notice returnable in 6 weeks. Petitioner takes steps for service of notice upon the respondents by registered post within 3 days. List the matter after 6 weeks. Then the next case, same order except the case number is 2185 of 21. Other than everything is same. Huh?
Obliged. Item 4.
My lord, item 4 to 9, same matter, my lord. In this matter, my lord, we need some more time, my lord, because we have prepared the model, my lord, and we have placed in the cabinet, my lord. Therefore, we need some more time, my lord, because subcommittee of the cabinet have to pass it, my lord. So we need 4 weeks for further 4 weeks time. My
You
lord,
see, the thing is that long time back, I mean, the cancellation of 29/6. So more than 1.5 months have gone.
yes, ma'am.
And your AG was saying earlier that within a week, everything will be done.
My lord, from our department, my lord, we have prepared and placed before the cabinet, my lord, but approval from the subcommittee is required, my lord. Because that decision was taken by the cabinet only, my lord.
Yes, what?
My lord, last time, your lordship, was readily interfered. And now we have so many decisions of the Honorable Supreme Court as well as division bench and full bench of the High Court that the policy decision should not be readily interfered by the court. So.
This is not a question of policy decision. This is a question of a decision already made by this court, which has attained finality as on date. You have to challenge that decision before the division bench.
Now, thing is this, that the government has power to give proper direction, that section 122 and section 12 of the Panchayat Act. So that direction government has every power. So that power should not be interfered readily by.
Sorry, we have interfered.
So
What
my
to do?
submission may be, I have also brought certain
You,
suggestions.
you see, Mr. Counsel, you can file an application for modification vacation. You can file. You cannot do it like this. This is not the way. This is not the procedure. You have to file an application for modification vacation of the order. Then only we can look into it. Not this way. This is not the way that today we do this, we pass an order
We
this
have
way.
also brought the judgment also.
Whatever, there is a procedure how to do
Yes,
it.
I know that, but last time also very casually, it is our.
No, it is not casual, Mr. Counsel. There was already a earlier judgment of this court. It's already a decided matter. So there's nothing casual about it.
Decided on the basis of seeing we have full bench judgment, we have got Supreme Court judgment.
So that is
But
what,
on the, at that time, it was motion instead, I did not think that your lordship would pass such type of order and readily on the motion day. So I did not come with preparation.
You see,
They appeared on KV8, man.
huh?
They appeared on KV8.
Anyway, they are aware.
They took time on
Correct.
RTO also.
So I thought some time, but
This
your
type
lordship did not grant.
Look, there's nothing remains in these cases actually. The only thing is that they should complete their, tender notice,
Private respondent has no locus.
No,
no locus.
No locus.
no, why not? We have paid.
Their term has expired, my lord.
We have paid.
Your settlement period has expired. Your settlement period has completely expired. You've got no rights. And if you think that this order, barring setting aside your extension is wrong, you can always go to the division bench. You can challenge this order. There's no bar. So you don't even have to come to this court again. You can always go there. No, even if,
We expected that the person would modify the order.
no, nothing. We cannot. I cannot. Because it's already a decided matter. When it is a decided matter, single bench or a decision of a coordinate bench cannot be decided. And in this case, not a coordinate bench. It is my judgment passed in a different case. And that was also based on another coordinate bench decision. Number of decisions which has attained finality, it has not been challenged before the division bench.
We
Or the
also
Supreme
find
Court.
decisions have been made Supreme Court.
Then you go, you please challenge it. You have got all the liberty, all the right to do that.
To go to international court also.
Huh?
You can go to international court of justice.
He can go anywhere. Only thing is that now, you see, there's no issue left. The only issue is when they will bring out the tender notice. The tender notice has to be brought out, the modified tender notice. That can be put to challenge if they want. So why should we keep these cases pending any longer?
Dispose it of it.
No, my lord, so
Exactly.
far the tender part is concerned, our whole case, my lord, everything is over. Settlement already, my lord, final, CS already done, everything over. And it is to be, my lord, NIT is to be floated from first June, my lord. It starts from 1st July. And from May, they know it, my lord. They are coming when they found that some of the favorable persons have not got, my lord, the selection in that case, my lord. That's why after everything is over, my lord, they have come, my lord, for modification. They could have done it earlier also, my lord. Everything is complete.
When are you filing? Otherwise, it's
My lord, we are waiting for the approval, my lord, for the cabinet.
because you see, you have to file your affidavit. we take a decision on whether to continue with the earlier tender notice.
That part we have already accepted with the.
What? Accepted what?
The interim order, my lord, we are maintaining.
I'm not on that. Now the next issue that will arise is whether the NIT, which had been floated, whether that will have to be taken to its logical conclusion or your modified NIT. So please complete the process. Let us decide which one should be followed.
My lord,
Whether there is any
earlier-
major change.
Earlier NIT is already by MP notification, my lord, all those were cancelled, my lord. Now we are
It is
just
understood.
Earlier NITs have not been have not been cancelled.
29/6, my lord.
29/6, yes.
All tenders, earlier tenders cancelled.
Last
Correct, correct. So now they're challenging 29/6.
Yes,
So, you see, we are not taking a decision now on 29/6 for the simple reason that your object seems a laudable object. But whether your modified NIT will redress the issue, put in that 29/6 notification. If it does not redress the issue, then the earlier NIT should be taken to its logical conclusion. So everything is being held up by you.
yes,
When can you take the decision?
my lord. My lord, just here, I'm repeating, my lord. The cabinet for approval, we are waiting, my lord. We have everything from our department we have done. We have placed, my lord, but the committee not yet, subcommittee of the cabinet, my lord, not yet finalized, my lord, approved.
So we'll have to wait, Mr. Chaudhary.
4 weeks time may be done.
You see,
It's not 2 months.
no,
Maybe-
4 weeks is
maybe-
too.
maybe-
small.
Yeah,
Complete, my lord.
Huh?
maybe in between, my lord, they approve, my lord. We will not stop there, my lord. We will continue, my lord.
No, then you take 2 years also. In the meantime, you complete this. You see,
Because, my lord, if our that is decided, it would be, my lord, the decisions, my lord, our department, my lord, then I can say, my lord, within 2 weeks or 3 weeks. But for cabinet, I cannot say that within 2 weeks or 3 weeks, they will approve, my lord. That is my problem, my lord.
They are part of the government. The parliament is government, madam.
and the problem is that you don't have any fundamental right to.
No, my lord, I have, because everything done, madam. Only that to issue the order.
Their main
Not
issue
mine.
is the second part, my lord. That is for the interim, my lord.
Or a settlement issue.
So,
Then
But
Then-
agreement was not signed, my lord.
so that is,
we'll give you last chance to fight. I will take a decision. If you don't, see, you cannot just keep everything in limbo like this. When you're going to take a decision, we do not know.
At least 4 weeks time may be done.
Why? 4 weeks. We'll give you 2 weeks
My
time.
lord, at least to justify, my lord, we will file the affidavit, my lord.
To justify, we'll give you
The
2 weeks.
decision of the government.
Look, if the government is not interested in taking a decision, why should we wait for the government to take its decision? You carry on with your earlier procedure, with the earlier NIT. You have to take a decision. You have stopped the entire, like he said, settlement order issued in his favor.
Also, my case.
Huh?
Settlement was issued in my name.
Mr. Council, your term has expired. You have got no, your term has expired. His term is to just start. That's a different thing.
Awax was about to mind the issue. At that very moment, somebody accused them and they got it modified.
No, but it's pan Assam, so you cannot say that it is only because of your case. It is all over. So
That
it's,
is their
My lord, may I pray, my lord, some observation may be passed, my lord, so that I can approach the department through the.
right. But this passes order in all the three, all
Six.
from
Four
item
4 to 9, my lord.
4 to 9. How does it matter? Forever.
Till the,
Okay, we'll say that wherever extension orders have been issued, till August, beyond August, it should not be given. Because it's already started halfway there.
clear.
More than halfway. Huh? Mr. Council, the second month is nearly ending. Now it's already 19 or 20 days. Then it's only 10 days. Right. Heard the councils for the parties. Also heard Mr. S. Datta, learned counsel for the PNRD department. The grievance of the petitioners is that despite tender notices having been issued for settlement of huts/fisheries, ponds, etc., the same have been cancelled pursuant to the notification dated 29/6/2024, issued by the Principal Secretary to the Government of Assam, Panchayat and Rural Development Department. Full stop. The Mr. S. Datta submits that proposal has been made for,
The model NIT, my lord.
has been made for,
Modified.
for issuance of the model NIT, which has to be given cabinet approval,
Subcommittee, my lord.
which has to be given approval by the
Subcommittee of the cabinet.
subcommittee of the cabinet. Full stop. However, the same has not been done till date. When did you give the proposal?
Not, August only, my lord.
Though proposal was given in when?
In this month, my lord.
When? Beginning, end, when? Middle,
Same
when?
date,
Given in August 2024. Full stop. Next para. You are in which case number? No. Six. Mr. S. Thakur, Learned Counsel for the petitioner in W 3632/2024, submits that. In his case, settlement order dated 26/6/2024 has been issued. And it is because of the impugned order dated 29/6/2024 that no agreement has been executed between the parties till date. The state respondents having decided to make a modified NIT. The same would have to be made the same cannot be delayed. Keeping in view the fact that the respondents had all, keeping in view the fact that the petitioners had all taken part in the various NITs issued. The state respondents cannot be allowed to delay the matter on the ground that the modified NIT is still to be approved by the government. Accordingly, in view of the above reasons, the state respondents should complete the process of modifying the NIT, which may be put to challenge within a period of 2 weeks.
Well, 4 weeks, my lord.
2 weeks. The state respondent shall also file their affidavit within 2 weeks. This is the matter. You heard it.
Date when will it?
My lord,
9th August,
my lord, at least
9th
3 weeks, my
August,
lord.
September.
My lord, 3 weeks, my lord.
Huh?
3 weeks, my lord.
That will, everything will go on. You'll also punch.
Because
So 1 year.
we are also waiting, my lord, because we are losing the revenue also, my lord. But because of the cabinet decision committee, my lord, we are waiting. My
You're taking decision, you're push.
lord. 3 weeks, my lord.
By September, it's
3 weeks.
about to 3 weeks.
Okay, 3 weeks. This is the matter on 9th September. That's right. It has Mr. A. M. Ahmed,
I am.
Learned Counsel for the petitioner in WPC 4076/2024, submit that the earlier settlement holder submits that the settlement period of the respondent number
7.
7 in WPC 4076 of 2024 has been extended beyond his settlement period. In view of the impugned notification dated 29/6/2024. Full stop. As this court has passed interim orders on all other petitions with regard to the inability of the earlier settlement holders to be given extension period beyond the settlement period, beyond the regular settlement period, comma. The state respondents are directed to no, no, don't say this. They said the extension of the settlement period of the respondent number 7 beyond August 2024. Is state.
Obliged.
Petitioner may be directed to serve a copy to the video, my lord.
Huh?
Petitioner may be
The petitioner in WPC 4076/2024 shall serve a copy
PNRD department.
of this order to the fishery department,
No, no, no.
PNRD, bro.
to the PNRD department,
Executive officer.
to the executive officer,
Borbeta Anshalik Panchayat.
Barpeta Anchalik Panchayat.
Obliged.
Let all these matters be tagged together.
Obliged.
May I please the washroom? These kind of things, telling the suppose notice for termination matter. In the meantime, new development taken place by. My contract already been terminated on Saturday, on 17.
Your contract has been terminated.
Terminated on 17.
Then there is an arbitration case pending, application.
Yes, petition pending.
Then you have to go now there. How can you come here?
No, it was filed prior to termination matter.
What was the prior to termination?
This particular petition.
Now, what do you want out here? What is your prayer here?
No, they are here, my lord, during the pendency of the arbitration petition, we have filed petition for appointment of arbitration. But during the pendency of that petition, my lord, they have issued this show-cause notice for termination matter. During some meeting. One case is there, since we have already.
That is why you go to the arbitration case. You see, when there is an arbitration clause
Yes.
for settlement of dispute between the parties,
Yes.
and you have already availed of that clause, you go there and take a decision. We'll close this. There's not, you cannot have two parallel proceedings.
Of course, by the time I have already been terminated on Saturday. This case is otherwise also gone, my lord, because already.
Okay, so you go there.
The only thing, my lord, as per my lord, why we have filed, my lord, because as per the terms and condition, my lord, since the contract work is more than 100 crores, my lord, it will be panel of 3, my lord, and they have to appoint the first arbiter, my lord.
That you have to go
Yes.
there. How can I decide? this?
Yes, no, in that case, my lord, that is the issue, my lord,
So
altogether.
you have to go to the court dealing with arbitration matters
Yes,
and make an application there
Fine.
for early hearing or whatever,
yes,
appointment of it. So, and then you can also refer to this
yes.
order. That's
This case technically become impact of it.
this case has become effective because of a earlier pendency of here. Yeah, the earlier that arbitration matter, that application for appointment of an arbitrator was prior to termination.
Yes, partner. Termination only a day before yesterday I have been terminated after filing of this matter.
No, how can it be?
Yes.
How can it be day before? This is filed on 2nd August.
They had initially challenged the show cause for
Show cause notice.
termination.
I have challenged.
Now,
this
now
for
the
show cause.
termination order has come.
Okay, this is a challenge to show cause. notice. Then this.
Yes.
Okay, right. Right, mister. Then this goes.
They are allowed to do it.
Okay. Okay, mister.
Hey, Chaudhary.
A. Chaudhary, Learned Counsel for the petitioner submits that the petitioner has challenged the show cause notice dated 16/7/2024. Full stop. However, after the filing of this petition, the respondents have terminated the petitioner's contract on
16/8.
16/8/2024. Pursuant to the show cause notice
Yes.
dated 16/7/2024. He submits that he may be allowed to withdraw the writ petition as the same has become infructuous. Mr.
BD Decca,
B.D. Dekha appears for
2 to 6.
respondents number 2 to 6. Mr. S.S. Roy appears for respondent number 1. In view of the writ petition becoming infructuous, the writ petition is closed as infructuous. Or you want to dismiss as infructuous?
11.
Acha, who, the caveat is there? Who appears for the caveat? Huh? Oh, you are for the caveat. Okay, okay. As the counsel for the caveat is present, the caveat stands discharged. Huh? Right. Next. Yeah, okay, right. Heard Mr. Jay Barbuya, legal counsel for the petitioner, who submits that the vehicle hire charges of the petitioner amounting to rupees 15,96,480 has not been paid. Issue notice returnable in 4 weeks. Mr. S. Roy accepts notice on behalf of all the respondents. This is the matter of the court. To enable the respondents to file their affidavit.
Only one thing, my lord, pendency of the case may not be barred.
Pendency of the case shall not be a bar for the state respondents to pay the admitted dues of the petition.
Yes.
12.
Heard, Mr.
And one more.
N. Burman, learned counsel for the petitioner, who submits that the contractual dues of the petitioner amounting to rupees 27,53,940 has not been paid. Issue notice returnable in 4 weeks. Mr.
M. Lordship,
M. We accept notice on behalf of
respondents 1 to 4.
1 to 4.
Yes, Lordship.
Anybody else?
Lordship for finance, I believe 5 and 6.
Yes, madam. Miss,
I am Baroya Lordship,
for
Finance Department of Funding.
5 and
for respondents number 5 and 6. Huh? This is the matter of the police to enable the respondents to file their affidavit.
13.
much obliged.
If you like. Yes, Mr. R. Sharma, learned counsel for the petitioner, submits that the petition's contractual dues amounting to rupees 12,78,669 has not been paid. Issue notice returnable in 4 weeks. Mr.
R.K. Musari,
R.K. Mushara accept notice on behalf of
2 to 5.
2 to 5. While Mr. R.R. Gogoi accept notice on behalf of respondent number 1. Same thing, huh? Other same thing.
14.
14 amount will be 19,39,003. Who accept notice?
I'm for one.
Same, huh?
Okay.
15.
So your representation has not been decided.
My lord, representation is not decided, my lord. That is on a spec. Actually, the council has got the authority to issue license, but that is not done. Anyhow, my lord, that representation
Let the representation be decided.
decided, yes.
That's all. This is a private cattle on their own land.
Yes, my lord.
I don't know, you see.
And that power lies with as per section, as per Act 1993. Boroland Autonomous Council Act 1993, under section 24, they are empowered to give license, my lord.
Okay, right. Heard Mr. M.A. Sheikh, learned counsel for the petitioner. Petitioners who submits that the petitioners are owners and patadar of a plot of land measuring of land measuring 4 bighas, 0 katha, 1 lechas, situated at village Katajhar, Gaon, in the district of Baksha, bracket BTC, comma, Assam, bracket Schedule A, bracket close. The petitioners who want to establish and run a private cattle market have submitted a representation dated 18/7/2024 before the respondent number 3. Praying that a license for running the private cattle market be issued to the respondents. The grievance of the petitioner, next paragraph, the grievance of the petitioners is that the petitioner's representation has not been decided till date. even though the respondent BTC have the power to issue a license under Rule under section 23, 24,
24 and 25.
24, 25 of the
Boroland Autonomous Council Act 1993.
You got it? Good stuff. Next para. The petitioner's counsel submits that the writ petition can be disposed of if a direction is issued to the respondent number 3 to take a decision on the petitioner's representation within a specified time period. Good
Page
stuff.
23, madam.
Huh?
Page
Miss R.B. Bora appearing for the
20.
respondents number 2 and 3 submits that she has got no objection to the prayer made by the petitioner's counsel. Who appears for one? You. Miss Udas appears for?
Madam. One.
Udas appears for point number 1. Right. In view of the consent of the parties, comma. The respondent number 3 is directly to take a decision on the petitioner's representation dated 18/7/2024 within a period of 3 weeks, 2 weeks. What, 1 week?
1 month.
Within a period, what?
1 month.
1 month? 3 weeks. Within a period of 3 weeks from the date of receipt of a certified copy of this order, along with a copy of the writ petition. The writ petition is accordingly disposed of.
A copy of the order may be supplied to us.
The decision taken by the respondent number 3 should be conveyed to the petitioners thereafter. The writ
Well,
petition is accordingly
yeah.
disposed of.
Here, my lord, it is requisition of vehicle, my lord. Area is not paid.
Heard Mr. M.A. Sheikh, learned counsel for the petitioner, who submits that the vehicle hire charges of the petitioner amounting to rupees 9,61,290 have not been paid. Issue notice, so except Miss U. Sharma accept notice on the respondent of all respondents.
Who does?
Same thing, huh? Others. You das, sorry. You das. Earlier also you das. Huh? In that item, in that 15 also will be you das, not Sharma. Huh? Oh, it's the same thing, like all the contractual dues, same order.
Maybe the method not payment of.
Mr. N.J.
Gogoi.
Heard Mr. N.J. Roy, contractual dues 19,03,915. Okay. Yeah, then who accept notice?
I accept notice on behalf of 1, 3, 4 and 5.
Mr. N. Upadhyay accept notice on behalf of respondents number 1, 3, 4 and 5. While Miss
I am Barwa, your lordship.
R.M. Barwa accept notice on behalf of respondent number 3. Okay, same thing. Same order, all 4 weeks. Okay, here, Mr. A.I. Uddin. Contractual dues of 10 lakhs. Who accepts notice? Miss Kemprai,
It's the-
for all,
No, lordship, 3, 5, 6 and 7.
3, 5, 6 and 7.
That's
Yes, Miss U Sharma for 4. Only. You das. And
corresponding to your lordship.
for about 1.
One.
Yes, Mr. M. Barwa.
Yeah.
M. Buya for 1 and 3.
3 I am appealing, lordship.
Okay, one, only 1. We have given, I think you've got everyone's name. You've got 2 also.
May I prefer disposal?
R.M. Barwa appears for
Responding to.
May I prefer disposal? Let them examine and within a
no, some,
my
we have to issue notice. First they know.
tendency, my lord, may not be.
Pendency of the case shall not be a bar for the respondents to pay the admitted dues of the petition.
Time out.
Lordship, if I may, lordship, our name has also not been reflected in the cause list.
Registry to reflect the name of Miss
SC Health.
S.C. Health. And you also, no, S.C. Health in the cause list.
Must be reflected.
My lord, matter may pass over the time being, my lord. In your council, my lord, the cancer is in lakes, my lord, court number 1.
What is the,
It's a tender matter, time being, my lord, is it in lakes, my lord, court number.
Just that I also have a matter coming up in code number 1. I'll do that and come back.
Treatment of artificial 19.
May I please lordship? Lordship, I filed for including the new respondent,
Okay. Third, Miss
Priyankana.
D. Angana, learned counsel for the applicant who submits that Shri Bhaskar Sharma, Chief Engineer, Water Resource Department, Chanmari, Guwahati 3, District Kamrup M. Assam, should be pleaded as respondent number 6. Ms. R.M. Dekha, appearing for the respondent number for the Water Resource Department. That means that she has got no objection to the application being allowed. Full stop. In view of the person of the parties, please answer so is pleaded as respondent number 6. Applicant to submit a corrected cost title, corrected/amended cost title to the registry within a week or within 2 days. Within 2 days. I have accordingly allowed and disposed of. Then in the main case, you're right. In view of the order dated 19/8/2024, passed in IAC 2293 of 2024. So is implemented as point number 6. Issue notice to the newly implemented as point number 6. Ms. R.M. Dekha, accept notice on behalf of point number 6. This is the matter. After 4 weeks.
Date may be fixed, lordship.
Okay, give it.
Item 20.
Yeah, my activity is ready, in fact, lordship.
Huh?
My activity is ready. Our process is not filed, lordship. We have disputed the demand law.
You have not filed.
I filed today. Today I'll file, lordship.
Let me see. Okay. Let me file this affidavit. Mr. N. Upadhyay, Learned Counsel for the Irrigation Department, submit that affidavit will be filed today.
Not today.
Accordingly, leave this matter on.
Monday,
Huh?
next Monday, Lord.
Next Monday, I'm not coming.
Okay. Sorry, lordship. Any day, lordship.
Next Tuesday. Give this back to him. Huh?
21 and 22.
You take back your affidavit.
Lord. My lord, in item 21 and 22, the respondent number 4 and 5 have filed their affidavit on Monday, my lord, last Monday. So I need time to file a reply, 4 weeks time.
Mr.
Yes, Chakravarti,
S. Chakrabarti, Learned Counsel for the petitioners, is granted
4 weeks.
Huh?
4 weeks, my lord.
4 weeks time to file affidavit in reply to the affidavit filed by the
Respondent number 4 and 5.
respondent number 4. This is the matter after 4 weeks.
My lord, there is an interim order.
Oh, because of that,
No, my lord. My lord,
you make it within 2 weeks.
my lord, 3 weeks, my lord.
Why? Right?
My lord, the respondent number 4 and 5 took long time to file. In fact,
Okay, make it 3 weeks. Interim order to continue.
Item 23.
may please your lordship. Lordship, in this matter, my senior was about to appear. He is election code number 1. I don't for time being, lordship.
Leave it for now.
In fact, affidavit was supposed to file by the prior petitioner lordship. As per the
He
law.
doesn't want to fight.
We will lordship.
Lordship, he will appear.
Let's wait for him.
All right.
24.
Yes, no affidavit.
Lordship, actually, this case is handled by Council Bigover, who could not be, the brief is also with him, Lordship. He could not come to court today because of some personal difficulties. Lordship, we give a short date, it might come again. He'll be able to better appraise the court, that is why, Lordship.
Otherwise, it is an admitted amount, my lord.
Where? No, there's not, that admitted amount of it.
Date may be fixed, my lord. Right.
Where do we fix? Right. A judgment prayer has been made on behalf of Mr. Bigo, learned counsel for the respondent. Due to some personal difficulty. So establish the matter on, give it.
29.
What's your pleasure?
Oblige, my lord.
Item 25.
Instruction is remitted, my lord.
Okay, no one appears for the petitioner. Mr. S. Bora, learned counsel for the respondents, number 1 to 4. Is granted. How much time?
2 weeks time.
2 weeks time to obtain instruction. Okay. This is the matter of the case.
26.
Lead to the Lordship. My lord, in these matters, my lord, issue was raised wherein, my lord, the running fisheries were intervened by some, my lord, orders passed by the Missing Autonomous Council and which were disrupted. And we put to challenge those orders, my lord. The other matters also connected before your lordship. My lord, today, my lord, my learned friend was supposed to bring instruction of file affidavit, my lord. Appearing for the fishery department, Mr. Fish.
Where is he?
Yes, sir, I couldn't contact him actually. I was trying to call him, my lord.
He must be around somewhere.
This must be in some court, my lord. Or I can do one thing, my lord.
We
There
can
are-
wait for some time.
Yes, my lord, I can wait.
We'll wait for some time.
If there are other matters also, may I just point out, my lord?
Yes.
My 37
Item 26,
and my lord, 37,
37,
37, 38,
38,
39,
39,
39 are similar, my lord.
and 41 also, I think.
My learned
20, 28 also. So
And
we'll
41
wait.
and
Huh?
and
So it will be 26, 28, 37,
I got it.
38,
And 41, my lord.
and 40, and 39, and 41.
41, my lord. Can be taken up after some time.
After some,
Lordship, I am appearing for respondent number 9, Lordship, in all the cases.
who are you?
Private
Private
respondent.
respondent number 9. So I need 1 week time to file affidavit, Lordship. in all the
Wait, let us hear everyone.
Actually, in this case, without affidavit, madam, the law involved, madam, no affidavit filed till today.
Correct, no affidavit is necessary actually.
Law is clear.
Lordship, since we are appearing for the respondent number 9,
No, you tell me the law. Once you
because
Once you cross the legal hurdle, the law, then we'll go on your fact.
no,
The simple thing is this. Can the MAC, the Missing Autonomous Council, settle fisheries in the state of Assam?
because the act has given us the power.
Show me that.
No, that is.
Show me
Whether
that. Show me that.
With the notification.
Therefore, Lordship,
Act
I-
is not.
I
Show
pray-
me. No. You see, affidavit not necessary. We are not on facts, please. We are on law, which you can say, you can just show it to me now. Show me the law.
Then Lordship, can it be taken up after some time? I'll
Yes, sir.
provide.
Yes.
I will certify law.
Out of some.
My lord, at 2 o'clock, if not inconvenient.
2 o'clock, we've already fixed a bunch. After that, we can do it. That's not a problem because I don't think this list will last till 2. I think it's going to finish.
Or else,
Ah,
Lordship, that's it.
Yes,
I'll
yes,
immediately contact Mr. Farma, my lord. I'll call
Can
him
it be
now.
taken up on Wednesday, Lordship?
No, wait. We don't want to do things in bits and pieces. We want Mr. Sharma's view also, besides your view. Okay, we will hear you, but we'll hear you all at the same time. Not you now, Mr. Sharma at 2 o'clock, another person, day after tomorrow, nothing like that. We'll hear you all together. And
Mr. Kothakuri is also.
after some time, yes, call them. Because my list is finishing.
Yes, my
In
lord.
another 20 minutes, it will finish.
Yes, my lord. Oblige.
27.
Here, my lord, I pray for some more time, my lord. I have received a letter, my lord, for verification of document, my lord. 2 weeks time may be granted, my lord.
Okay.
That can be disposed of, my lord, examine and verify, my lord. If I'm entitled, let them give, otherwise
After
not.
2 weeks, my lord.
Sorry, not so easy. Mr. Miss U Sharma, you Das, learned counsel for the respondent. Submits that she has received parawise comments.
My lord, I have received.
Submits that
praying
she
for
has not
some time.
received parawise comments. he is accordingly granted 2 weeks time to obtain instructions and file affidavit. This is the matter of 3 weeks.
Obliged.
May be fixed, my lord, and
Give a date after 3 weeks.
September,
Deeply obliged, my lord.
29 and 30.
29 and 30.
Please, your lordship, may I kindly pass over the matter for the time because
Everything we pass over, then who will hear?
senior counsel is on like as we speak.
Who is the senior counsel?
PD Das.
We cannot pass over everything. Everything is being passed over.
Lordship, may kindly accommodate us first.
Where is he? Which
Court number
court?
10.
Court number 10.
Yes.
Okay, let us see you. But once it finishes, if it does now, if it's not there, then we are going to agenda matter.
Lordship. Obliged.
Yeah, I'm going to finish my list in a few minutes. Yes, thank you.
Subsequently, admitted 49.
Like no one appears for the petition on call. The matter pertains to non-payment of contractual dues amounting to rupees 6,21,423. Who appears for the Miss
I'm a the finance department.
Miss Aaron Barba appears for the phone number. For the respondent, for the finance department. This is the matter after 3 weeks. But we're finished.
29 for orders.
29 to this.
My lord, in this case, my lord, respondent chief engineer filed affidavit, my lord.
Hmm?
And he admitted the fact, my lord, page 44, para 6 and para 8. Page 44, para 6 and para 8 last part.
Yes, who is appearing for the other side? Yes, Miss, yeah, so you all have admitted,
amount
Huh?
is admitted. Lord.
then you pay. If you admitted, what order can we pass?
Lordship, may kindly see paragraph 7 also, Lord.
Huh. Correct. Heard Mr.
Yeah, ma'am.
A. Mohammed Leonard counsel for the petitioner. Mr. N. Upadhyay appears for the irrigation department. Yes,
I am for respondent number 6
your name?
and for one on behalf.
Miss M. Burman appears on behalf of Mr. S.C.
SK.
S.K. Mary. Leonard counsel for
It's accounting general.
Accountant General. No, Accountant General's office. Miss R.M. and Mr. R.M. Barwa appears for point number 5. What's that? Right. The petitioner's case is that he is a registered class 2 contractor under the irrigation department, government of Assam. Pursuant to a notice inviting tender bracket NIT dated 11/11/2014, inviting tenders from registered contractors of the irrigation department, Assam for the scheme, invert commas, construction of canal from tail point of extension of NOA NADI I/S bracket from CH full stop 14868.00 M to 16,000.00 M. Brackets close. Inverted commas close. Under SCSP during the year 2013, 2014, under Mongoldoy division bracket irrigation. And with the approximate value of rupees 29,47,100 bracket in group number 2 bracket close. The petitioner was allotted the work was allotted the following work. Then in the synopsis itself it is there. Construction of canal lining sensor till here in blue and blue. The other one is also here, in the NIT. That scheme is there. Okay. The case of the next para. The grievance of the petitioner is that despite completing 66% of the work and submission of bills for the completed work of 66%, the respondent number 3, the respondents have not paid the contractual dues of the petitioner amounting to 17,37,956. The next para, the petitions council submit that as there is an admission by the respondents in the affidavit, the position filed on behalf of the respondent number 3 with regard to the claim made by the petitioner, a direction should be issued to the respondents to pay to the petitioner the admitted amount. Next. What have you got to say?
Lordship, only, Lordship, in fact,
Huh?
availability of
Okay.
fund, Lordship.
Right. Mr. Upadhyay, the learned counsel for the irrigation department submits that the petitioner could not be paid the admitted liability amount of rupees 17,37,956 due to non-availability of funds with the department. Full stop. I have heard the counsel for the parties. Full stop. The claim of the petitioner for non-payment of his contractual dues amounts to 17,37,956. Full stop. The same has been admitted by the respondents, by the respondent number 3 in his affidavit at para
6 and 8. It's particular.
6, 7, and 12. Full stop. And a comma, which is as follows, you take that down. At page 44 and 45. On considering the fact that the petitioner's contractual bill is an admitted amount, the respondents are directed to ensure that funds are made available for payment of the admitted dues of the petitioner amounting to rupees 17,37,956 within a period of
6 months.
No. 3 months.
It can be after March only, Lordship.
3 months.
In think after March only,
Why after March only?
but it will come on. In the month of March.
Why March?
3 months, my lord. Case is pending from 2022.
When did you complete the work?
I may not,
When did you complete the work?
I may not, they not provide the money, my lord. They don't.
When did you complete the work?
You have not completed the work.
You have not completed the work.
Petitioner is ready
Number
to
2,
complete, my lord.
when did you file your writ petition?
2022.
When did you stop doing the work?
I stop, my lord. Come along, my lord.
When?
My lord, the opponent of the did not, they are.
I have to say within 6 months from the date of receipt of a copy of this order. You're lucky. Actually, there'll be a clause in the contract agreement that the balance work will have to be paid by the third contractor.
Alright.
You should give him some treat. In fact. Retrieve petitions accordingly disposed of. Yes,
I'm being 26, 28, 37, 38, 39, and 41.
Lordship, in this series of cases, your lordship, in 4 cases, my name has not been shown, your lordship, that's why.
no, it's one case is enough.
Lordship, now your lordship, in this series of case, your lordship, what has happened, we have filed one affidavit, your lordship, in connection with the cases filed by S. Banik and others, your lordship. And those were made part-heard by another bench. Issue is same, your lordship, coordinate bench, your lordship. And I have not served copies on them, your lordship, since these cases.
So we will make all these parted here also.
Lordship, that's.
And you find, no, you see, if all the affidavits are same, then you please put it
I will.
Put it here. Okay, because then we'll decide the entire issue.
I have just pointed out your
Yes,
lordship.
I know. No, what I'm saying is, look, the thing is that if that other bench decides, then this bench will follow the judgment.
Lordship can do that.
Okay, we will do that. Or if it doesn't decide, then we'll decide.
Lordship. I will do one thing, your lordship. I will serve copies on them, your lordship, in this case.
So when do we list this matter?
As per your lordship, so tomorrow itself I will serve copies.
Tomorrow, sir. In all this item 26, 28, 37, 38, 39, 41.
Lordship. And also probably 48.
Huh?
48.
28 is also there, 28 is also there.
28 is there.
28.
What 48? 48 is not, that's
No,
a different.
48 is different.
That's a different. That will take it up at 2.
Lords.
No, that's different, but then the facts are slightly different. But I think the issue will be the same. Sadly.
Issue will also be different in that case. We have nothing to do.
We have got nothing to do there. We are taking that up at 2.
My
Okay,
lord,
right.
I have just a small prayer, my lord, to make. My lord, if my learned friend, Mr. P. Sharma, is able to file similarly one affidavit for all cases, that will perhaps, my lord,
Instead of filing everything, I will provide instruction lord. Which are purely.
You see, because he's supporting you all. So he doesn't have to file any affidavit.
he
He's
is
supporting you all.
basically supporting my case.
He's supporting your case. Only Mr. S. Bhattakur
Mine is also your lordship on factual part. I have not made any.
is only on the law. Only on the law. So you give it them by tomorrow, all of them. Then we'll list it when? Thursday or Monday?
My lord, I have difficulty
Tuesday.
still, my lord, for Friday, my lord, I'll be out of station. So if it's on
Okay,
Monday,
Tuesday we'll
on
fix it.
Tuesday will be convenient.
Tuesday we'll fix, next Tuesday.
Next Tuesday will be convenient, my lord.
In the meantime, if the other bench finishes it up,
Lords.
then it's okay. Then we'll follow that.
Lords. 27.
But if he doesn't do it, then we'll decide.
Lords.
My lord, we
Okay,
have a-
right. Mr. S. Bhattakur, Learned Counsel for the Missing Autonomous Council submits that he will provide affidavit in the position only with regard to the legal aspect of the matter, as has been done in a similar case earlier. Full stop. He submits that the matter can be disposed of on the next day. Accordingly, list these matters on next Tuesday, 27. Then items will be 26, 28, 37, 38, 39, 41. Okay. Common order. They tag this matter along with on and list the matter on 27 as part of it.
my
My
lord,
name may be shown.
my lord, we have interim, my lord, we are given interim protection.
Interim orders,
Can be extended.
interim orders shall continue till final disposal of the case.
Yes, lord, I'm highly obliged.
Then That's all?
Oh, that's all. That will do, your lordship.
Acha, registry to reflect.
No, your lordship, I
Money.
have already noted this. Your lordship.
Much obliged, my lord. Much obliged.
Deeply applied.
32.
Maybe the lordship. So I, for implement of party.
I will I. I don't know. You'll file.
Yes.
Oh,
Then maybe done.
for improvement.
Yes, lordship.
Okay. Item 30.
32.
Yes, what is your case?
Lordship, we have filed our affidavit. The proposal has been sent, Lordship.
Huh?
Proposal has been sent
To whom?
to Brahmaputra Lord.
Huh?
To Brahmaputra Board, Lordship.
Mahaputra board. Was Mahaputra board a party
No, Lordship.
in the writ petition?
No, Lordship.
And did you take the plea that Mahaputra board has to pay the amount?
No, Lordship. We will pay the amount. The amount has to come from Jal Shakti, Lordship.
Jai Shakti.
Yes, Lordship. But Jal Shakti is also not a party here.
Have you complied with the orders passed by, where is your letter to the Brahmaputra board asking for money?
Page number 169.
116.
69. Annexure 1, Lordship. We have sent a status monitoring report, Lordship.
169 is a letter by the petitioner.
Lordship,
Show me. In whose affidavit?
our affidavit, Lordship.
Affidavit of?
Roshan Kumar Chaudhary, Lordship.
Roshan, who is he?
He is the executive engineer. Modi Council.
One detailed document, that's not to promote.
Actually, they are what? They are two. They are what? They are two 169. No problem. Two 169, yes. This is supposed to be different. Mr. Counsel, this is only a status report.
Yes, Lordship.
Where is the request for money?
Brahmaputra Board will forward it, Lordship.
To whom?
To Jal Shakti, Lordship.
This is a status report, Mr. Counsel. It's not a request for money for payment of fund. Where have you stated that the petitioner has completed his work and this much fund is necessary? Where have you stated that? Who is this person who's trying to take this court for a ride? Who is he? Let him come to the court.
No, Lordship. Lordship, they will, Brahmaputra Board will forward it to the Jal Shakti, Lordship.
Mr. Counsel, where is the request for payment of money for funds?
Then I'll file the affidavit, Lordship. Sometime maybe.
You tell your executive engineer to please follow the directions passed by this court. It's not the way. There's nothing. Right. Mr.
I am.
R. A. Ahmed, learned counsel for the petitioner. Submits that he needs to file an application for impeachment of,
Jal Shakti and
contempt.
Esplanade 1 and 2. As well as Jal.
They were parties in the writ petition.
No, Jal Shakti not party. Esplanade 1 and 2 party. Esplanade 1 detailed lordship.
Okay. Application for impeachment. Where's the route? No, just say that. Don't say it. Then you say. Mr. What is the name?
Sharma, Lordship.
C. Sharma, the land counsel for the respondent number 3. Shall file an additional affidavit No, shall inform the respondent number 3 to file an additional affidavit. Giving a status report with regard to the work completed by the petitioner and the amount of funds, amount of dues payable to the petitioner. The respondent number 3 shall also submit the forwarding letter by which funds had been asked for payment of the same to the petitioner. This, respondent number 3 shall file affidavit within 2 weeks. So, failure of which may invite consequences. Please take it seriously. This is not the way. We're not doing, This is the matter after 2 weeks.
33 also similar.
Huh?
I think 33 also similar.
Same,
Same case.
same thing.
Yes.
So same order.
Yes.
I done 33 also same.
34.
Give it IA. Implement.
My lord, contempt, my lord, amount for my lord, land acquisition not yet paid, my lord. So long back, my lord. See, kindly see, my lord, last order dated, your lordship order, 24/7/24. Mr.
Long, how can it be long ago?
Well,
24/7 is just last month, not even a month.
2004, my lord, land was taken in 2004,
No.
20 years back.
Yes,
Lordship, may I pray that this matter be taken up on Wednesday? Proper instructions are with Council B. Google, Lordship. May I pray that this matter,
Mr. Bigo is not here today.
can this matter be taken up by next week?
We can do that. We'll list it on Thursday. Only thing, what is this IA? IA is for,
My lord, I am
reading.
not necessary because my lord already, my lord, my lord, district administration forwarded for the dispute.
So we will close this IA then, if you're not pressing it.
Yes.
Or you want to withdraw this IA?
Yes, my lord, I see.
What do you want?
My lord, I am my lord executive engineer.
Mr. Council, do you want to press this IA, withdraw this IA, what?
Not press.
Then withdraw. Okay, Mr.
Yes, Chairman.
S. John Learned Counsel for the applicant submits that he may be allowed to, says that he may be allowed to withdraw the IA. Mr.
MPL, Lordship.
Mbuya appears for
B. Google. Council.
B. Gogoi, Learned Counsel for the PWD.
PWD.
The prayer of Mr. S. Chauhan is allowed. The IA is accordingly closed as withdrawn. Then in the main case, you write, in view of the adjournment prayer made on behalf of Mr. B. Gogoi, Learned Standing Counsel PWD, list the matter on Thursday.
Eight is Lordship. I appear for the restaurant number 1, Lord. It was already retired, Lordship. Direction was to the Water Resources Department. Similar to item numbers 32 and 33.
No affidavit has been filed, I think.
No, Lordship, the Water Resources has to file the affidavit. The officer commissioner of the
Who
water.
is for the Water Resource Department?
Number 3 is the chief engineer, Lordship, the Water Resources Department. They are supposed to forward their proposal to the Ministry of Jal Shakti. Then Jal Shakti will do the needful, Lord, as per the direction. At page 4.
So, you see, final opportunity was granted to you to file affidavit by 12/8/24. You have not filed. We will frame charges against the chief engineer. Huh?
Our name is not reflected.
They have not appeared, Lord. Other respondents not appeared, Lord. Only respondent 1 has
Oh.
appeared, Lord. 1 is the then chief secretary, Lord. Although direction was to the Water Resources Department, respondent 1 is the then chief secretary. 2, 3, 4, and 5 is not appeared, Lord. But the similar issue is similar to item number.
No, but the respondent number 1 has wakalatnama has been filed on behalf of respondent number 1.
1 year, Lordship. Okay, Lordship, uses the order at page 14.
So who is the chief secretary out there?
Then Chief Secretary, Pawan Bhattacharya.
So he's no more, he's no longer.
I filed the Wakalat on 4th of April. He retired 31st.
No one appears for the petition. Mr.
A Das Siraj.
Adas appears for the respondent number one and submits that. The respondent number one is no longer the chief secretary,
Yes, Siraj. He
How much?
retired on 31st of March,
as he retired on 31/3/24.
2024.
Then, right, as per office note, dated 28/6/2024. There is no return of rating card or unserved notice from the respondents number 2 to 4. Notice issued to the respondent number 5 has been received back as unserved/undelivered with postal remark bracket addressee left. As no one appears for the petitioner, this is the matter after 3 weeks.
Pavla Xerox.
It says.
Make the last. Well, this for review of the
Huh?
last order.
What order do you want reviewed?
Lordship, thereafter, they,
Huh?
they allow to, this temporary connection manner. And after, we are now on temporary connection manner. But we have a hardship manner because in every month we have to pay 5,000 manner. So we have submitted an application before the manner consideration for permanent connection. But since this.
What is wrong? That is not a ground for, that
No,
is not
my
a ground.
my
So your case is, if you are granted a permanent connection, your payment will be less.
Yes.
There's no ground for.
I have submitted application that was, not
Then
allowed.
this is a review, Mr. Council. There's not a writ petition. Sorry.
Another ground also, my lord, I have filed a writ petition, my lord, and as the interim, my lord, I paid for my lord temporary connection. And my main prayer was not, my lord, considered, my lord.
That would be a ground for appeal, your lordship, if at all.
Yes, you file an appeal. There's nothing. There's
My lord,
nothing.
only, my lord, only I seeking your lordship. My lord, I have filed an application. They are not, my lord, because this honorable court granted, my lord, temporary connection.
Mr. Council, sorry.
Lordship, may kindly see my.
Heard Mr. Right.
Application, my lord.
Heard Mr. G, the learned counsel for the petition, review petition. Also heard Mr. KP Pathak, learned counsel for the APDCL. Who is for respondent number 6? No. The first time?
Yes.
First time, right.
Right.
Mr. No, the petitioner, the review petitioner has paid for review of the
Ground page 16, my lord.
order dated 3/5/2024. Passed in WPC 2315 of 2024. Wherein this court had directed that the petitioner should be given the liberty to make an application to the APDCL authorities for grant of a temporary connection. And the same should be provided by the APDCL authorities, if the petitioner was in occupation of the premises for which the electricity connection was sought for. The said direction had been passed by this court in pursuant to the decision of the Supreme Court in the case of Dilip through bracket dead through LRs versus Satish and others, reported in 2022-0 Supreme bracket SC 1485. The next para. The petitioner's counsel, the review petitioner's counsel submit that the petitioner had, in pursuant to the order of this court, applied for grant of a temporary electric connection, and the same was provided to the petition. However, the petitioner wants a review of the order in as much as he has to pay, how much, 5,000 more? He has to,
5,050, my lord,
he has to pay rupees 5,050
every month.
to the APDCL authority for the temporary electricity connection. And if the same was converted into a permanent connection, comma, the petitioner would have to pay how much? How much? Less. Would have to pay a lesser amount.
Yes, sir.
Would have to pay a lesser.
Whatever I
amount.
consume.
So that is their case.
My lord. Another ground, my lord, I have submitted representation, my lord, that was not considered only because this honorable court was in order, my lord.
He submits that the petitioner had submitted a representation which has not been decided by the respondent authorities. First of all. That's all. Mr. KP Pathak, Learned Counsel for the APDCL submits that no grounds for review has been made out by the petition, by the review petitioner, as can be seen from the submission made by the petitioner's counsel and the contents of the review petition. That's all. I have heard the counsel for the parties. That's all. The next para. The grant of temporary electrical connection had been made by this court in the order dated 3/5/2024, passed in WPC 2315/2024, in view of the fact that there was a property dispute between the petitioner and the respondent number 6 in the writ petition. And no, first of all, further, the title suit number 98 Sec 4. The civil court.
Civil judge, my lord.
But
Junior division
before
number
the
two.
civil judge, junior division number 2, comma, Kamrup M. Guwahati. As can be seen, no, as indicated above, comma, the property in question for which temporary electricity connection had been given is a disputed property. The submission made by the review petitioner's counsel and the contents of the review petition do not indicate that there is any error apparent on the face of the report or any mistake has occurred in the order. Yeah, this court does not find, this court accordingly does not find, no, this court accordingly finds that no case for review of the order passed in WPC number 2315/2024 has been made out. The review petition is accordingly dismissed.
I have representation pending before.
That is a different issue. This is a review, Mr. Counsel. I cannot go beyond what the review allows.
1340.
But Mr. KP Pathak, why don't you take a decision on the thing, on the representation?
Lordship, because your lordship had granted us, had directed that we should consider an application for a temporary connection. That has been done. After the connection has been granted to them, now they have submitted the representation.
Correct.
That will perhaps amount to interference with your lordship.
Correct. If he wants, he can go in appeal.
Yes, sir.
Lordship may divide in manner that consider on merit matter.
Well, the ground of review is very difficult. You're not agreed with the order.
In Supreme Court.
You're agreed with the payment of
No,
the charges.
My writ petition was, my lord, the prayer was, my lord, the for.
Then you challenge it. You challenge my order. You challenge my order. You challenge
Only,
it.
my lord, the restriction is the, since this order,
Huh?
this honorable court order is there, my lord, they are not considering my representation. So they can consider as per law, my lord. Only that direction, lordship.
Next.
May I please, Your Lordship, I am for the respondent number 8, my Lordship. On Saturday, I have filed a wakalat now.
Who is it?
8 is Mrs. Mamoni, so the respondent number 8.
The occupier on the third floor.
Who has allowed the construction to the
Other private respondent. Notice of sought to be issued to 5, 6.
5, 6, 7, what has happened?
Office note has.
Notice
stated
issued on 6, 8.
That is the only information.
So 6, 8, not even a month has passed. It's just. So
The
today is
vacant
19,
steps on
13
29
days.
itself. The
No,
vacant steps-
whatever.
Yes, but yes, notice of issue on 6.
So what to do?
To post it after some time, because notice has gone and it has appeared.
In fact, Your Lordship, there is an interim prayer measure that Your Lordship had stated that the pendency of this petition shall not be a bar for the authority. They can proceed in the meanwhile.
Why are you not taking action?
Yes, they can proceed in the meanwhile. They can inquire. That is, inquiry is the only relief that we are seeking.
My Lordship, I want time for filing affidavit, and
Mm.
what is the main reason? The petitioner is not a owner of the flat, my Lordship. He is not a owner, he has filed one civil suit, my Lordship, in civil court for specific performance of contract. Till date, she is not the owner of the. How can she demolish the others property, my Lordship?
That's why we have not passed any
Yes,
stay or
that
anything.
is, Your Lordship had given an interim measure to.
You just give you file an affidavit. How much time do you want?
I seek time.
How much time? 1 month?
Others are not official, my Lordship. Builder has not.
Okay, Mr. P. Bhardwaj.
M. Sharma. No, P. Bhardwaj can be also.
Mr. P. Sharma appears for the, huh?
M. Sharma.
M. Sharma appears for the petitioner. While Ms. S. Bora appears for the response number 1 to 4. Mr.
CS Rai.
CS
Rai.
Nayak.
Rai.
Rai. CS Rai appears for the response number 8. And prays for a month's time to file affidavit, 4 weeks time to file affidavit of position. Praise the Lord. Then you're right. As per office note, notice was issued upon the respondents number 5 to 8 on 6/8/2024. Await service report. This is the matter after 4 weeks.
If I may pray for a date as per Your
Give
Lordship.
a date.
I'm grateful, Your Lordship.
Time being added 42.
May it please your Lordship. No, my lord, in spite of the limitation of your lordship's power to assail conditions of tender, my lord, I am putting a challenge to the tender itself, because in my humble submission, my lord, this tender lacks the essential ingredients of a tender. There is no element of any evaluation
Essential conditions
of a tender. Allah, that offer and acceptance part is there, that unconditional offer and acceptance part is there. But there is nothing in this tender to evaluate the my lord eligibility of the tender bidder. My lord, the price is fixed, the model is fixed. All that is required is my name should be registered with the employment exchange. Then, my lord, there will be a draw of lot and that will decide the tender. Is it a tender, my lord? Then it should have been named as a lottery. Kindly see, my lord. Please come to page number 46.
Yes.
Kindly see, my lord. Number of categories, there are 6 categories. For example, Mahindra and Mahindra Bolero, 278 vehicles. On top, my lord, before that, hiring of services of brand new 372 number of light vehicles, taxi for Assam Asset for a period of 4 years on lottery basis. This is the scope of the work. And similarly, my lord, other models are 28 numbers of Mahindra and Mahindra Bolero diesel. Then category 3, Tata Yuddha pickup, it's 45 numbers. Then Toyota Innova Krista 1 number, Maruti Desire petrol 3 number, Mahindra and Mahindra Scorpio Classic 17 numbers. So in all 372 below. Now kindly come to the modal subdivision. Then please come to the next page, my lord. Page 47. Against the draw of lots, third column. Against the current requirement of 372 vehicles under the tender, a total of 500 applicants will be selected by the first round of draw of lots, that is shortlisted applicants. The first 372 would be ranked as shortlisted applicants and rest 372 to 500 subsequently ranked as waitlisted. So first 372 would be the shortlisted ones. The rest would be Milord out of that 500 waitlisted. Then Milord will kindly come to next page as far as the price part is concerned. Page 48. Applicable rates for category 1. So all the rates are given. This is the amount which a bidder, if he is successful, will get for the different categories. So there is nothing to, my lord, evaluate. Evaluation is already done. Then my lord will kindly come to page number 51. Sorry, page number 52. Three, brief selection procedure for award of contract. My lord will kindly come to page 53. Applications from individuals having valid employment exchange card and employment from employment exchange of any of the following areas shall only be accepted. So prima facie, this clause is violative of Article 15 and 14. So you cannot make any classification based on place of residence. Then on submission of the applications to application portal, a system generated 6-digit number will be allocated to each applicant, which will be considered for draw of lots to be held as per the schedule mentioned in para 1.1 above to select the applicants provisionally against the tender. It must be understood that documents for the provisionally select applicants after draw of lots will be strictly scrutinized as per para 4 below. So 3 and 4 are the basically correct. So from here we find, my lord, one needs to be an employment exchange registered bidder. Then C, only shortlisted applicants which are found to be eligible after scrutiny as per para 4.0 below will be considered for further processing. Self-attested copy of one of the following document: birth certificate, passport, driving license, school certificate, and affidavit from this sworn in before executive magistrate, PAN card, admit card. Then self-attested copy of following document: ration card, passport, voter ID, current bill, etc., etc. Then Milord will kindly come to page number 56, 4.0. Applications will be rejected in the following cases. Before
Just
as
a
well
minute,
as
just a
after.
minute. 4.6,
4.0, Milord, at page 56.
which should is,
Because it says eventually it will be done as per 4. If the applicant is not submitted through application portal as mentioned in this tender, if this scan copy of signature and photocopy is not uploaded, if scan copy of valid employment exchange card is not uploaded, then my lord, if the proper scan copy of age proof document is not uploaded, now E is very important. If the age of the applicant is found to be below 18 years and above 50 years, as on the original closing date of the receipt of the application. That means the applicant has to be not below 18 years and above 55 years. Well, what is the basis of this intelligible difference here, my lord? What is the object sought to be achieved?
well, 18 years will be licensed, you cannot have below
And
18
why
years.
55, my lord?
Maybe they want, maybe age, they want a person with a good reflex.
No, my lord.
Mm,
I can
taxi
appreciate
driver.
he's a driver, but there are owners also. There are two categories. Then Milord will kindly come to page number 108. Technical specification of vehicles. Please come to serial number 2. M Mahindra and Mahindra Bolero B4 diesel with AC or equivalent make and model vehicle as per manufacturer specific. Okay. Duty hours 24 hours. That means because there are two categories, one is self-driven, other is owner car. That means the driver has to work for 24 hours. Self-driven. Then my lord will kindly come to the notes.
Which one are you talking about?
2 my lord. At
Page 108.
Yes,
Yes.
2.
2.
Duty hours 24 hours.
Huh.
For 2 and 4, duty hours is 24 hours. It has its significance when Lordship will read page 109, then will Lordship will get to know. Just I'll referring to it, my lord. Then please come to the notes. The offered light vehicles should be brand new vehicle with BSI emission norms. So and so with all standard fittings, etc. And no issues with this, my lord. Now 109. Please come to 13A and B. Light vehicles have been classified into different categories, self-driven, ownership. Light vehicles shall be driven by owner himself throughout the contract period. Owner has to give written undertaking that if at any stage it is found that the vehicle is being driven by some other driver, the contract shall be terminated with immediate effect. Now, please now correlate this clause with 2 and 4 of page 108. Because one who gets under the self-driven category, he cannot deploy a driver. Now he is to be ready for 24 hours. Does the labor laws of the country permit this, my lord? Then my lord B. Light vehicle has been awarded to contractor. Contractor may hire driver for driving the vehicle. For this category, why this upper age limit of 55 years is required, my lord? I can appreciate one who is driving 55 years putting a cap, okay. Well, at the end of the day, what I'm trying to show, number one, there is no criteria in the debate document to evaluate the eligibility. Now, Lordship knows in Michigan rubber, Supreme Court has come up with some of the essential features of a tender. And one of the condition D is the tender must contain some criteria to evaluate the eligibility and financial capability of it. So here there is none, my lord. The price is fixed, model is fixed. There is no scope. Only thing is you have to be, your name has to be registered with the local employment agency. That's the only criteria. Now, can it be constituted as a tender? Now, please have this Michigan rubber case, Miller. 2012, 8 SCC, page 216. Para 23 at page 229. Milord will kindly come to subpara D of para 23. Subpara D of para 23.
Yes.
Certain preconditions or qualifications for the tenders have to be laid down to ensure that the contractor has the capacity and resources to successfully execute the work. So one amongst others, my lord, the tender must contain some eligibility criteria in order to ascertain or evaluate the eligibility. Now, what is there in this case, my lord? Is it not just a draw of lot? Only requirement is one needs to be, and my lord, how can you confine this selection to 4 districts of the state? Is it permissible under the Indian Constitution?
You are from where?
I'm from Assam. There is no difficulty.
So
I'm from
you're not bad.
I'm not bad. But I'm just posing a question to your lordships, my lord. And now an illegality is before your lordships.
No, but that no right of yours has been violated. And
My
you are,
lord-
you are not filing this case for,
My lord will
on
appreciate.
behalf of
no,
somebody
No,
else.
no, my lord will appreciate one thing. Yes, I am not filing a writ petition on behalf of any else. But if an illegality comes to the notice of a 226 court, Supreme Court says 226 court should take note of those. An illegality has come to your lordship notice. And it's an illegality which goes to the root of the matter. It's not an illegality, my lord. It's a something which is trying to, overcome the constitutional embargo. So my simple argument before your lordship is, here is a tender which is bereft of any eligibility criteria. It cannot be construed as a tender. Therefore, my lord, authorities should come up with a tender, laying down, my lord, minimum terms and conditions. Minimum. That's my only case. I'm not attributing any malafide or anything. Maybe bona fide they did it, but it's wrong. In the absence of any eligibility criteria, lordships will not permit the authority to go ahead. So, my lord, and apart from those arguments, I have already shown two clauses wherefrom it is evident that they're restricting the competition to some Upper Assam districts, number one. Number two, my lord, they are making a classification is which they cannot. And thirdly, my lord, there is lack of competition. Why we say, my lord, competitive bidding? The expression competitive bidding has to be given, some meaning has to be given. If gross lot from eligible, from, my lord, employment exchange candidates are to be the only criteria, then it can't be a tender. That's my.
Have you participated?
Like, no, my lord.
Why?
Tomorrow is the till tomorrow there is the last date. my lord.
Do you have the eligibility criteria to
Yes, yes.
participate?
Only thing is, my lord, I have to be registered with the employment exchange.
So are you registered?
And yes, yes. We fall in the category of driver cum owner, not the owner one. There are two categories, driver cum owner and other is owner. We fall in the first category. Yes,
Driver-
we have the
driver-
eligibility. In fact, what? I don't know. We are eligible, my lord. We are otherwise eligible, we can participate. But my lord, this criteria, end of the day, my lord, there will be no evaluation. That's the only case. Whether that can be permitted. That's my humble submission.
My lord, before I address your lordships on the merits of the case,
My lord, with your lordship's kind permission.
before I address your lordship on the merits of the case, I'm questioning the very maintainability of the writ petition. Your lordship will find that if your lordship comes to the cause title,
Yeah.
the lordship will find that the first petitioner is some self-dependent motor driver union. They claim to be a registered trade union, which they have annexed the list of members, which your lordship will find at page 37. And if your lordship comes to, that continues up to page 39, your lordship will find that they have 93 members. There is no resolution of the body allowing them to file the writ petition. The other petitioners are all in their individual capacity. There are hardly about from petitioner number 2 to petitioner number 13, 12 individual petitioners. All right, they can maintain the petition, but the petitioner number 1, without an authority from the body, it cannot maintain this writ petition. For the simple reason, we don't even know whether the other 81 members have authorized them to file the writ petition at all. The reason is very simple. Assuming they have 93 members, we take this document at page 37 to be a correct document. Again, for this tender, we have already till today morning, till midnight yesterday, we have received 18,000, almost 19,000 tenders. So at best 93 are agreed.
Even if
This is since yesterday.
till yesterday.
Till yesterday means 18/8.
Your lordship can, yes. By this morning, it was,
Sunday is open.
no, it's online submission. So they can submit anytime. And today morning, it must be higher. So assuming this petitioner number 1 can maintain, at best, there are 93 people who are agreed. Against that, we have already received near about 19,000 tenders, which means a large overwhelming majority are perfectly fine with the tender conditions. The reason is very simple. Why they have come before your lordship is, over a period of time, these people have created a monopoly. Now this time that monopoly is getting broken. And what they have not disclosed to your lordship is something very interesting. So my second ground is that your lordship will dismiss this writ petition because of serious suppression of relevant and material facts. In fact, my lord had the occasion to deal with this. This is the tender that we have come up with. Your lordship will kindly have a look at it. This is pursuant to a policy decision taken, which was tested before your lordship. Your lordship will first find the minutes. This will refresh your lordship's memory. My lord had the occasion to deal with this case. There was a tripartite meeting between the stakeholders, the district administration, and the ONGC officers. And pursuant to that, these decisions were taken, which your lordship will find at the second page. After threadbare discussion on all the issues, it is decided that tender for single vehicle will be acceptable for single individual through lottery. And your lordship will kindly see the last paragraph. Further, the district commissioner requested the ONGCL authority to review the matter at their level and come out with a rational solution that genuine demand of unemployment may be addressed. It is for this reason we have kept the age between 18 to 55, because to process this whole tender, it takes about near about a year. So 55 plus 1 year is 56, and the contract period is for a period of 4 years. So that takes the successful bidder to the age of 60. So the whole idea, the policy behind this entire tender is to provide a means of livelihood to the unemployed youth. That is why that age of 18 to 55. Now, if your lordship kindly sees, turns the page.
How are we supposed to dispose of this matter today?
It's come for the first time, only for consideration of the interim order. Now, if your lordship kindly turns to the next page.
Yes.
Your lordship will find the change in policy. And this is what was put to challenge. Evaluation of tenders for hiring of light vehicles in Assam. EPC in its meeting held on 7/9/23 reviewed the evaluation of tenders for hiring of light vehicles in Assam and decided hiring of light passenger vehicles on one applicant to one vehicle basis at the rate offered by ONGC using draw of lots. As per decision taken by EPC, provisions of integrated MM manual, that is the policy document by virtue of which we hold all our tenders, have been modified in respect to evaluation of tenders for hiring of light vehicles in Assam as per attached annexure 1. And that annexure 1, your lordship will find at the next page. And your lordship will find the whole idea is, since it is to provide a means of livelihood, serial number 2, your lordship will find bids will be invited at ONGC offered rates on one applicant, one vehicle basis. And then the third paragraph therein, only one online application will be accepted from one applicant if at any stage it is found that an applicant has submitted more than one application in his or her name against the tender, that is either after the submission of applications or during scrutiny of applications of provisionally selected applicants through draw of lots or during pendency of award of contract, then all the applications submitted by such applicants will be rejected and the performance securities, etc., will be forfeited.
draw of lots to be held among all the applicants in presence of so and so members of the indenting department. Now, if your lordship will kindly turn the page, your lordship will find why against 372 vehicles, we are keeping a wait list from 373 to 500, that your lordship will find at serial number 5. A few applicants will be kept in a waiting list with a validity period of 1 year from the date of draw of lots for any future requirement. These applicants subjected to fulfillment of NIT conditions shall be considered for filling up of vacant positions in the priority list resulting from any rejection of selected applicants, cancellation of contracts after lottery, or additional requirements of the company, if any. This is why we are keeping that waiting list. Now, this policy was put to challenge before your lordship, which your lordship will find the judgment immediately thereafter. And as I was pointing out to your lordship, my lord had the occasion to deal with this change of policy. This is a judgment, the page third page will reflect that it is a judgment of 18/6/2024. And if your lordship kindly turns to the last portion of para 2, your lordship will find that this very policy was put to challenge. At page 4 of that internal page 4, line about 4 from bottom. The petitioners are also aggrieved by the letter dated 19/9/23 issued by the so-and-so, wherein it has been decided to hire light passenger vehicles on one applicant, one vehicle basis at the rate offered by so-and-so using draw of lots. So this very policy was put to challenge and your lordship rejected the entire challenge. Your lordships discussed how, if your lordship will kindly come to page 6, paragraph 8 onwards, your lordship discussed how it is permissible, particularly at para 11, that high security number plate case, your lordship has in fact held that there is a change of policy which is permissible and which was held in this judgment 2010-6 SCC. And at para 12, your lordship has said this one. In the present case, there is nothing to show that the change in policy by the respondents for applying the one vehicle, one applicant principle is unreasonable, biased, or arbitrary. The change in policy for awarding the contract on the principle of one vehicle, one applicant was made on the basis of minutes of the tripartite meeting held on 8/8/23. The members in the meeting consisted of district administration, the ONGC, and various organizations of Sibsagar. Though it is reflected in the meeting minutes that the representatives of various organizations have threatened to declare a ban on so-and-so, if the tender of the so-and-so was not relaxed, the meeting finally resolved the issues raised by the various organizations as follows. Your lordship has quoted the decisions taken, and at para 13, your lordship has held that this would be in public interest, naturally because unemployed people would be getting some means of livelihood. And accordingly, this petition has been dismissed. And pursuant to this dismissal, we have floated the fresh tender. So therefore, it is a consequence of the policy which has been upheld by your lordship that we have done. Two things are being said, madam. Mainly, they want to say that if you are holding a draw of lots, where is the evaluation? The reason is very simple. Earlier, when we fix the rates, it used to be this much must be the minimum rates. This time we have removed the word minimum so that all vehicles, assuming we hire 10 Toyota vehicles, Toyota Innova vehicles, why should one Mr. X get 3,000 rupees? Why should the other one get 3,100? To maintain that uniformity. Otherwise, this does not entail rocket science. This is not construction of some.
So this is only to get the base rate or the.
This time we have fixed the rates that all will be getting the same rates. And how do we determine? And draw of lots, your lordship is aware, even under section 102 of the Representation of People's Act, when there are two candidates get the same number of votes in an election, it is to be decided by a draw of lots. Under Right to Education Act, in terms of section 12, draw of lots is how you decide on the reservation, 25% reservation. So therefore, what is the arbitrariness in the entire decision-making process? And that is what your lordship had noted in the earlier judgment. Now, the other point that is being sought to be raised is that how can someone perform 24 hours duty without placing the relevant clause Your lordship will kindly come to page 126.
Yes.
Page 126, clause 43. There are several paragraphs. Your lordship will come to the 6th paragraph. For 10 hours duty vehicles, overtime shall be payable if the service is required in excess of 10 hours. However, if the vehicle is notified for 24 hours round the clock duty, the overtime shall not be payable but 24 hours standing charges only shall be payable. The refueling on the round the clock duty shall be arranged by the contractor without disruption to the duty. Last sentence. The contractor shall provide 2 drivers for the 24 hours. We are asking for the vehicle for 24 hours, not the same driver to, we also know.
We are saying that in some, the owners are supposed to drive the vehicles.
That we will differentiate. When the owner gives, or that is why the language is mandatory. The contractor shall provide 2 drivers for 24 hours. So the moment a car is given for 24 hours, he will indicate the names of the 2 drivers. That these are the 2 drivers will be allocated to this vehicle, and this will be the duty hours. So therefore, my lord, what has been now so far as this law, this employment exchange thing is being said, that is the district administration has made a request to us that kindly see that the unemployment in the locality is taken care of. That is why we are asking for employment exchange cards, so that we can verify that he is actually an unemployed person. So in this entire decision-making process, where is the arbitrariness that your lordship will intervene in a terms of invitation to tender? Your lordship is aware of the law, right from Tata Cellular, right from Isaac Peter. The law is very clear. The terms of invitation to tender are not open to judicial review. And here is a case, they are themselves saying that they are eligible otherwise. The only problem is, in the earlier tenders, when there used to be a tie, because we had said minimum rate, assuming we have notified a minimum rate of 3,000. 2 persons quote 3,100 rupees. So how do we determine? We used to give preference to experience. What has happened is, these are the persons, because they have monopolized the whole thing, fresh entrants cannot come. And this is merely driving a vehicle. It does not involve driving an airplane, flying an airplane, or it does not involve flying a rocket. It's a simple thing. We are asking for taxis, and we want to give an equal opportunity to all. That is what it is all about. This is certainly, in my respectful submission, this is certainly not a case for stay. And your lordship may issue notice, examine the matter, will file detailed affidavits. In fact, there are further mischiefs. They say that lottery is not a way of evaluation. The clause pertaining to draw of lots has been always there. I can point out right now, the previous tender, only because they were beneficiaries in the earlier round, they conveniently suppress this aspect. That is why they do not even refer to the earlier tenders. So, lordship will kindly see, this is the earlier tender. So, what we used to do earlier is, if there is a tie on the amount, we would first examine the experience. After examining the experience, assuming there is a further tie, both of them have, let's say, 5 years of experience. Then how do we decide? Then draw of lots was always there. So it is nothing new, nothing that they themselves haven't taken the benefit of. Therefore, my lord, your lordship may issue notice, we will file our affidavits. And in any case, it is, if your lordship, there is another aspect I must point out. They are themselves saying at paragraph 2 that their contracts subsist till December 2024. So there is no question of any interim. The fresh contracts will naturally come after that.
All the petitioners have contracts.
Yes.
All of them.
Up to December 2020.
My lord, my senior counsel, my lord, Sabin, my lord, that
24 hours duty, my lord. We are the, my lord, self-driver, come owner, my lord. My lord, it categorized, my lord, page 109, my lord, my senior counsel already, my lord, submit, my lord. That there are two categories, my lord, self-driven and ownership, my lord. We are the self-driven, my lord. Ownership, my lord, my senior, my lord, submit that earlier case already lordship disposed of. That, my lord, that case was the ownership only, my lord. They are, my lord, some, my lord, the 4-5 vehicles, my lord, my lord, getting, my lord. We are not, my lord. We are last tender, my lord. We are getting, my lord, self-driver come owner. My lord, himself, my lord, itself, my lord, is differentiate, my lord. Kindly see, my lord, light vehicle shall be driven by owner himself throughout the contract period. Owner has to give written undertaking that if at any stage it is found that the vehicle is being driven by some other driver, the contract shall be terminated with immediate effect.
That has to be read with the other clause. That in case of 24-hour vehicles, you have
That
to
is
give
my
two drivers.
ownership in case of ownership, my lord, that is not applicable because, my lord, they use, my lord, the driver, my lord. But we, my lord, cannot, my lord. It is
No,
not,
no, so you see, what they are saying is that now when you go to 108,
lordship. Clause 2
they are
and 4.
10 hours and 24 hour duty,
Lordship.
okay? Now, when you come to page 126,
Lordship.
the second last paragraph, last line, the contractor shall provide two drivers for all 24-hour vehicles. So this will not apply to you.
Yes, my lord. But that is why, my lord, that is a latent patent defect, my lord, in the case.
No. So if you are if you are a self-driven vehicle,
Lordship.
then they will not use your vehicle for 24 hours.
But lottery is, my lord, is a game of luck, my lord.
So,
My lord, that is why, my lord, they.
no,
in
lottery,
tandem, my lord, two
you see,
categories.
the lottery system, you see, the issue is the rates.
Lordship.
The lowest rate, I think their main aim is to get the lowest rate.
No, we have already notified the rates.
The
So-
rates are already there.
That is why everyone, the rates are now, it's going to be the same for everyone.
Ah.
So how do we decide whom to give? So
Correct.
therefore, we have adopted the draw of lots. 18,000 applications. So how,
19,000.
lottery is the only option.
My lord, in NIT, my lord, chef, my lord, there are two categories, my lord. I have stated in my paragraph, my lord.
Yeah, what time? If
My
this
lord,
issue,
I humble prayer, my lord, in the meantime, we have filed, my lord, the representation, my lord, as per the NIT clause, my lord. My lord, let them, my lord.
In that contract, where is the
dispose
question
my
of
lord.
representation?
Till then, my lord,
and
no,
then tomorrow is the last day. No, heavens will not fall.
my lord, already we have filed, my lord, on 8, my lord. 8 August, my lord.
Where is the
Yeah,
question?
now we are, it's come to this court, now we will decide. Since they're not deciding, we will decide. We won't stop the process. Third, Mr. Ken Chaudhary, Leonard Senior Counsel for the petitioner. To submit that the petitioner number 1 is the self-dependent motor driver union. Which has (93) members. While the petitioners number 2 to 13 are individual petitioners. The petitioners have put to challenge the impugned NIT being tender number R16 DC2 4005 for inverted commas hiring of services of brand new 372 numbers of light vehicles bracket taxi for Assam asset for a period of 4 years, for a period of 04 years on lottery basis. Full stop. Back close. Full stop. The petitioners counsel submits that the petitioners are all qualified to participate in the tender process. However, due to there being glaring ambiguities in the impugned NIT, the clarification sought for by representation dated 5/8/2024 and email dated 9/8/2024 in terms of para 12.0 of the NIP has not been considered by the authorities till date. Next para. The petitioner's counsel submits that the NIT lacks essential conditions of a tender to evaluate the eligibility of the tenderers who serve. He submits that besides the absence of eligibility criteria in the NIT, there is a restriction in the NIT for persons who want to participate in the tender process. In this regard, he has in this regard, where is that 4 districts? In this regard, he has relied upon
53, my lord.
clause 3.0 bracket A of the NIT. 3.0 of the NIT, which provides that applications would only would only be accepted from individuals having employment exchange card from employment exchanges from 1 Sib Sagar, number 2 Nazira, number 3 Sonari and Moran. He, however, submits that the petitioners are not disqualified from participating in the tender process due to the above clause. Question. The petitioner's counsel further submits that the age criteria in the NIT provides that the applicants should be between 18 to 55 years at the time of the closing date of the tender of the NIT. At the time of submission of the tenders in terms of the NIT. He further submits that the manner in which the respondents, the respondents are going to pick the selected tenderers, that is by draw of lots, is illegal and in violation of section 3 of the Lotteries bracket Regulation bracket Act, 1998. he also submits that as per the NIT, comma, vehicles can be detailed for 10-hour duty, 10 hours duty or 24 hours duty. He submits that as per the NIT, the self-driven vehicles, which has to be driven by the owner, comma, it would be unreasonable for the authorities to expect a self-driven vehicle to have to be allotted duty for 24 hours. He thus submits that the tender, the conditions in the NIT have to be clarified in as much as the provisions therein inhibit the lack of competitive bidding. That's all. In this respect, now he submits that the respondents have to in the provision has to formulate conditions in the NIT. The formulate preconditions or qualifications in the NIT to ensure that the contractor has the capacity, to ensure that the tenderer has the capacity and resources to successfully execute the work. They accordingly praise that till the respondents take a decision on the petitioner's representation and there is clarity to the requirements of a tenderer, comma, the NIT should be set aside. And in the meantime, a stay on the operation of the NIT should be affected. AFF affected. Next para, Mr. I. Chaudhary, Learned Senior Counsel, assisted by M.K. Das. Acha, the other one you say Mr. Dihinge, huh? Yeah, that's good. Submits that the petitioner number 1, which is the union, requires a resolution authorizing the petitioner number 1 to file the petition. However, the same is absent in the present case.
Not even a statement made.
No, sir. He further submits that no statement has been made. They'll produce now.
Thank you.
I don't
In
know.
affidavit, my lord, it's clear, man.
Huh?
In affidavit, it's clear, man.
That will not do. When a petition is filed, you have to annex the resolution. Otherwise, how do we know? All of them may not be in agreement.
That is no problem, no. He'll produce it on the next. Okay, right. Then it submits that no such statement, no such affirmation has also been made in the writ petition. Yes, sir. He further submits that there has been suppression of material facts. How is this material fact?
These three most relevant, that this NIT is pursuant to a tripartite
Yeah.
agreement.
Comma, in as much as the NIT is pursuant to, has been made pursuant to.
A tripartite meeting held between the stakeholders, the district administration and
Has
ONGC,
been made pursuant to a tripartite meeting held on 8/8/23
followed by
in the
amendment of the
office
policy.
of the district commissioner Sibsagar um, where it has been recorded. No, that's all. Don't say where, full stop, huh? Further,
Pursuant to that, we have amended the policy. And that policy has been upheld by this honorable court.
and further further, no, just say further, it persists to the minutes of the tripartite meeting held on 8/8/23, comma, the ONGC has amended their policy, well, the amendment.
Second paragraph, as per decision taken by EPC, provisions of integrated manual have been modified in respect of evaluation. And the modifications are also annexed.
That document, my lord, we have not received, my lord.
Anyway, has been, what do I say?
We modified our
The,
policy.
huh?
We have modified our policy.
The ONGC have modified their policy. In respect of evaluation of tenders for hiring of light vehicles in a cell, which is provided in the letter issued by the ONGC on 19/9/2023. So, he further submits that the challenge made to the modification of the policy of the ONGC and the letter dated 19/9/23 in WPC number
6208 of 23.
6208 of 23 has been dismissed by order dated 18/6/2024.
So on these two views of the matter, we are questioning the maintainability. So your lordship will keep the maintainability issue open.
Next paragraph. Mr. I. Chowdhury, learned senior counsel, further submits that as on date,
Almost 19,000.
almost 19,000 tenders have been received for hiring of 372 vehicles. First off, he further submits that the processing of the tenders would take about a year. Would take a lot
A few
of,
months, your lordship.
would take a few months. And thereafter, first off, would take a few months. First off, he further submits that the validity of the contract between the petitioners, all the petitioners are there, between the petitioners,
We don't know about the other members of the union, but at least these 12,
private,
the 12 who are there, petitioner number 2 to 13,
okay,
they are having subsisting.
what have I said? Petitioner number 2 to 13 is valid up to December 2024.
We have stated, my lord, in that regard, my lord. Yeah, all are, my lord, continue.
No, I'm putting it in the order because we don't read everything sometimes, we miss out. Imagine if we read each and every page of this. We have got to read 40, 50 cases, we won't. He further submits that a self-driven vehicle is not required to be on duty for 24, is not required to be driven by the owner for 24-hour duty. Inasmuch as clause 43 of the NIT provides that, inverted commas, the contractor shall provide 2 drivers for all 24 hours vehicles. Full stop, inverted commas close. So, next, issue notice, returnable in 4 weeks. Mr. MK Das. Accept notice on behalf of respondent number
1 to 9.
1 to 3.
Union.
Yeah. 2, 2, 3, 4. Mr. S.S. Roy, accept notice on the respondent number 1 While Miss Yu Das accepts notice on the respond number 5. This is the matter after 4 weeks
May I pray for a date?
to enable the respondents to file their affidavit. Full stop. Next para. On considering the submissions made by the parties and keeping in view the fact that the change of policy by the ONGC has not been disturbed by this court in WPC 62028 of 2020. This court is not inclined to grant any not grant any interim order in this case.
Well, that
So
order-
Lordship will keep the maintainability issue open.
So the maintainability of the writ petition can be kept open.
My lord,
Deeply obliged.
your lordship order, my lord, 6208, meant paragraph 12, my lord. My lord, it is clear, my lord, that my lord, some my lord declared some Assam bond. That is why my lord earlier tender was my lord not my lord finalized. But we are the my lord continue my lord one vehicle, my lord, one applicant, one vehicle. We also my lord support my lord. My lord, kindly see paragraph 12, my lord.
Yes.
The Lordship has recorded it.
But here, my lord, the earlier, my lord, the petitioner, my lord, in WBC number 6208, we are not that, my lord. We are the sale driver, my lord, come owner, my lord. We also support, my lord, one applicant, one vehicle, my lord.
So?
But, my lord, due to, my lord, there is some, my lord, the technical, my lord, tender, my lord, itself, my lord, is, my lord, contradictory, my lord, clause, my lord. Your senior counsel, my lord, submit, my lord, on page 109, my lord, and respondent counsel. my
Actually,
lord,
there's that, just one more thing. That, yeah, okay. Oh, no, not required. Just say, however, any decision made, taken by the respondents will be subject to the outcome of the writ petition.
Your Lordship may fix it on 20th.
20th of September.
September.
20th.
That will be after 4 weeks. Obliged.
obliged.
Timing item 23. Last occasion, my lord, Honorable Court by order dated, my lord, please may kindly see my last order dated, my lord.
Huh?
By order dated, my lord, 18/7.
This is item?
My lord. 18/7/2024, my lord. Para 4, my lord. Para 4, my lord. On the other hand, perusal of the
Just a minute, paragraph 4. Off, on the other hand.
my lord, your lordship, or last order, my lord.
Paragraph 3.
No, 4, my lord.
What does it say?
That today so and so advocate money, so and so. However, the instruction is incomplete as to whether the house standing thereupon is situated in Dag number 167 of Capic Patal so and so. The said instruction will be placed before this by way of an affidavit by the respondent on the next day. Affidavit record.
And the house is in 157. No construction in 158. No construction in 168. Huh?
No construction.
In 167 also.
Yes.
Then what was the petitioner showing?
Lordship, in this matter, they have filed, one affidavit has been filed by respondent number 6. So we need time, Lordship, to file.
Madam, this is a question of fact. Even if the best you can do is you can disagree with him. Now, if you disagree with him, if you agree with him, then the end of the matter. If you do not agree with him, what can this court do? You have to go to civil court.
Yes.
That's the logical conclusion. There are only two things you can do with a fact-finding inquiry. Whether you agree or do not agree. That's all. And if you say you agree, then the case is finished. If you say you don't agree, then you go to civil court. That's all. What else? We cannot now but for a writ court, that's more than enough. We cannot go beyond that. Where is anybody there?
Yes,
Mr. Das, you were there. This is your earlier you were there.
They will take time till Friday for filing reply to their application.
No, what is the, you see, the thing is,
167 was what I understand was subject to, because I did not take full instructions in the matter. 167, 168 and all those two more drive, it belongs to a family. There was no partition.
no, you
But
see,
the construction is there in probably my lord 168.
no, no, no. Now you see this court on the last date has said, however, the instruction is incomplete as to whether the house standing thereupon is situated in dock number 167 or 168. Kata number says. The said instruction be placed before this court by way of an affidavit
Their reply, but
by the respondent number 6. So this court has directed the respondent number 6 to place its instructions by way of an affidavit by the next date. So he has filed it.
they filed, but I'll just, my lord, your lordship will give 1 or 2 days.
No, no, just see it. Why should we waste time? That's what I'm saying. Why should we waste time? Again, sending it to the registry. Because this also, this says that a para 3.
Krishna Kapoor. Yeah, they are saying there is no construction of the proposed wine shop is observed in dock number so and so, which was also reflected in our letter number so and so. The affidavit filed by respondent number so. This is so.
So that is that. Now, so there's
Construction is not required, your
Huh?
lordship. It is not a construction, this is a lease they have taken. Once I get the allotment, then they will start construction.
no, but that is the problem.
Yeah.
Assuming that lease was to be taken, that is the ground that you have not taken lease from all three. You have taken lease from only one, while the entire 167 is owned by 3 brothers.
Yeah, that is.
Then, so on that ground
But
also you.
these three
you fall.
brothers, they are willing to give no objection.
That
now.
is a different thing, whether
Now
they are
the-
giving the, but then your document
if-
was not proper.
If the 3 brothers gives my lord, no objection, they will consider it. my lord.
No, no, but it has to be done at the initial stage. Cannot be done now. In that event, though, everyone will say, I'll get this land whenever the license is given to me.
Another, my lord, major point was, my lord, I'm filing additional affidavit for inquiry, and after inquiry, it was stated his proposed land is 167. And 167 in adjacent land to the
That's
there is
that's school, that's school.
LP school. I
School is just a few meters away.
43 meters. You cannot.
Anyway, that is a different issue. You see, the respondent number 6 has been asked
My lord,
as to what is the issue, and that has been clarified. Now, what remains?
my lord.
Mr. Guru, there is 150 golden goat, case taken up.
Like last quarter, there's no construction and this agreement of tenancy.
No, there is a construction in 167. There is a construction, but there is no construction for a shop because this residential house of the Patadars along with a small grocery shop are on that. So that small grocery shop is there and residential things are there. There is no construction of the wine shop.
Agreement tenancy logic has no construction.
For the wine shop, there is no construction.
Notarized by 5 years cannot.
Huh?
Notary, that was notarized for the purpose of 5 years. The notary,
Notary,
registration act cannot be allowed without, only for 1 year. More than year must be registered. 11. Must be registered, my lord, more than 11. Section 17 of the registration.
Okay, right. Yes, Mr. Biswas. End of the matter. There's nothing with Mr. Das. No, no, no. I will. We don't withdraw. Okay.
Liberty to, if necessary, my lord, to approach the authority only. With liberty.
Okay, with the liberty to approach the authority. Okay, right. Mr. B.D. Das, the Senior Counsel, assisted by Mr. S. Biswas, the counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to approach the concerned authorities.
We'll show it, man.
Then Mr. R.R. Gogoi appears for
For number one,
first point number 1, 2 and
4 and 7.
1, 2, 4 and 7.
Yes.
Miss
I-
U Das appears for 6. Huh? 3 and 6. 3, 5 and 6. And Mr.
And Bora.
Appears for
That's one number 8, man.
point number 8. N Bora for point number 8. The petitioner's counsel is the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn
Right.
with liberty to approach the
Authority.
concerned authorities, concerned official authorities.
The interim order may be vacated. Man.
Interim order stands vacated.
Much.
Now you can start.
Much.
The review petition. The 30 minute is a retired person minute. They have started deducting, but by virtue of your stay order, it is stopped. Similarly situated cases.
Item 30,
30.
29 and 30. Where is the other side? Here's a review petitioner.
Whether review is maintainable, you also will see that.
Review petitioner, what is this?
If, my lord, this petition is hasn't filed to.
No, his case is only basically one ground.
Yes.
That if they are not grade 2, they are grade, they are not grade 3, they are grade 2 employees.
2.
That's all. So that is the simple ground. Because this case was disposed of on the basis of Rafiq Masi's judgment.
Yes.
Now Rafiq Masi speaks of
That has been also there.
3 and 4. Great. Now, so we thought that they were 3. Now he says that they are 2. They are grade 2. So how do we? So that's the small issue only.
Category 2 is,
How do you say they are 2?
my lord, this is the gazette notification.
Is it here in the is it here in the review petition?
Review petition, my lord,
Which
At-
page?
page 42, 1144. my lord. This is the gazette notification.
42 relevant?
42, 1144, my lord.
42.
They are holding the post of staff nurse, master.
Staff nurse.
Yes.
How do you say they are grade 2?
Grade 2 means that they are carrying the P-band, P-band 2, my lord.
So pay band
Oh.
2 means grade 2?
Yes, my lord, subsequently 45, my lord.
How is pay band 2 be grade 2?
P-band 2 depend upon carrying.
So pay band 1 will be grade 1
Yes.
and pay band 7 will be, pay band 5 will be what grade? Grade 5?
3 and 4, my lord, it is depend upon that. Next page, my lord, 45.
No, just pay band 2 will be grade 2.
It's depend
How-
on the
Where
level.
does it say that? How do we come to that?
pay level, my lord. This is depend upon the pay level.
Yes.
Only next page, my lord.
Where page?
Next page, 45 and 45, my lord.
45, yes.
45, column 2, my lord.
Huh?
Column 2. 2 in the middle, my lord.
Yes, yes.
45.
Okay.
Central Service Post carrying the following grade pay. This is 5400, 4844, 4800, 4600, and 4200. The nurse is for 4600, they are getting 4600, and the right hand side is a group D, payment 2, my lord. And as for my lord, next page, my lord, 46, my lord, 46. 46, it is
Yeah.
it is a office memorandum of Government of Assam, Government of India to categorize the post under the employees. A, B, C, and D.
No.
And the next page, my lord. 48, my lord. 48, 2, my lord. The central civil post carrying the pay in the pay matrix at the level from 6 to 9, the group B.
Let us see 6 to 9. What is the pay matrix at level 6 to 9?
6 to 9, so my lord, it is contained in the pay matrix, my lord.
Where is the pay matrix?
Pay matrix, my lord, there. I have a next one, my lord, at page 55. my- Fifty-five.
What is this?
Revised basic pay, 7,450 miles.
So?
So they are carrying the pay level 6 to 9 miles, 6 to 9 level.
What do you mean 6 to 9? Where is that 6 to 9? Where does it say 6? Where does it say 9?
55 mile page.
Huh?
96, you're not saying.
Huh?
Page 96.
Fif-
Earlier it was group C, now it is group B, as per this notification.
Pay 9.
No.
Their salary in hand, my lord, I have stated, it is about 29,000. Everything is deducted by them.
No, where it is? Group
Page 96, your lord civil candidate, change of nomenclature and classification for the post of staff nurse, nursing sister and assistant nursing sister. So staff nurse is group C. Now it is known as group B.
Ah.
New nomenclature. So nursing sister is group C, non-ministerial, and now it is called group B. And assisting nursing superintendent, group C, now it is known as assisting nursing superintendent. We are on 2020. That is from 2020. And Rafiq Wasim, that 5 years thing is also there. So not only this grade 2 and grade 3, my lord, 5 years is also there. So their main contention, what I read from the paper, they are saying that we have given an undertaking at the time of getting the thing.
That is one.
If there is a mistake, if there is undertaking, my lord, their higher persons, my lord, this undertaking will not be applicable to they cannot take away the laws. And I've given 2 judgments are there.
But I think there are some other judgments also. No?
Yes.
That when they are
Balmer
going.
case is there, no? Balmer case is there full. I'll give a
No,
full.
should we take it after lunch or we take it some other day when?
Any day, any day.
Thursday?
The review doesn't lie, my lord. It's an appeal in discourse.
Thursday?
Thursday.
This is the matter on Thursday. So we've got one item. there.
I'll just indicate briefly, indicate what each petition is about.
Yes.
The petitioner was settled with the fishery.
Hmm.
Now let us consider ABCD to be the boundary of the fishery. Couple of days after I get possession, when I go to fish, my members, now persons from the missing autonomous council, not the autonomous council, the persons from the missing autonomous council exercise muscle power and do not allow me to do it. Immediately, I write to all the jurisdictional authorities on record. I'll give the page number. Nothing happens. Fearing that there would be a risk because I cannot pay because they do not allow me to operate in my boundary. So what to do? I approach this honorable court that the government would initiate a risk sale now.
Risk sale?
Risk sale is if I fail to pay the guests,
it will be sold again by tender, and the differential cost is to be borne by me. That's the risk here. This honorable court passes an order of status quo. That is in WPC 783 of 2021. First, I say the possession was handed over on 10/12/2020.
Just a minute.
My lordships.
Possession,
Handed over on
before possession settlement order,
my lordships.
and prior to settlement order, NIT dated.
My lord, I'm coming to that. my lord. Lordship finds at page 32, 18 November 2020.
18
November
November 2020 is
Start
the
from there.
NIT.
No, this is the settlement order. Settlement order.
18/11/2020. Where is the page
32.
of 976?
No, the last case, 97, yes, 976, correct.
And what is the NIT dated?
My lord, NIT, I have to check, It appears there was earlier settlement who could not, the earlier lessee could not do so. Correspondingly, proceeding was there where we emerged as the highest value bidder and it was given to us, we being the second. That is not in dispute to us. That is page 32. Page 32 is the order of settlement.
Then agreement,
My lordships.
agreement signed.
We said everything done. Those difficulties
Okay.
not there.
So
Now,
possession taken on
position is given at page 35, 10/12/2020.
10/12/2020.
2020. Now, when I face the difficulties, I write to the authorities, page 36, 40, 44, 48.
36.
40, 44, 48.
Representations dated
11/12/2020 at page 36.
yes
11/12/2020 at 40.
11/12/2020 is at page 36.
Also at page 40.
Same,
Same,
similar.
different person, addressed to different person.
Okay.
At 44 is 15/12/2020.
48.
And 48 is 5/1/2021. So far as 36 is concerned, it is to the circle officer, Dimmu Revenue Circle. Forty is concerned, it is officer in charge, Nitai Police Station. 44 is concerned, Deputy Commissioner Dibrugarh. And 48 is concerned is also Deputy Commissioner Dibrugarh. Now, I not only indicate my difficulties, I also name the persons who are creating this mischief. I indicate. Nothing happens.
And what is your prayer? Prayer was for what?
My
What is
prayer
your prayer?
to take necessary actions, renovation against the persons and facilitate our mores in collection of revenue. We cannot collect the revenue, kindly do it. But nothing was happening. We approached.
When the question of revenue, when you operate a fishery, you have to fish, no, basically.
We have to fish. And
Sell.
the fish is auction. Now, auction, it goes to the market or some fishermen would sell, that's a different issue. But we have to pay the revenue to the department from this auction sale. Now, if we cannot even go and fish, then there's no question of revenue. So it is at this point of time, fearing invocation of the risk sale clause, we filed WPC 783 of 2021. Order of this Honorable High Court is at page 50 in that case, which says status quo. Status quo order is.
With regard to?
No coercive action will be taken against the petitioner. We say.
Because you could not pay the
Because
fee.
I'm not in a position to pay. I inform all the authorities, but no one is taking action. Tomorrow there will be a risk sale clause. So this honorable court passes an order, no coercive action against the petitioner. Page 50.
976.
No, that is 783. 783.
One by one,
Yes.
I will give reply one by one. If they have Lordship, goes one by one.
Huh?
One by one, Lordship. I want to give reply, Lordship.
Okay.
Which is 976, I will reply, Lordship.
No, it's okay. We will come to that.
Okay.
I'll just give you the backdrop of the case. At this point, we file 783.
I.
Correct.
May I take?
Autonomous council, we are not against them per se.
We are against an individual, basically.
We are not against individuals. The effect of this is falling on us. So 783 is pending. This is the issue, and that is item number 44.
What have you prayed in 783?
We have prayed that kindly see that these actions are taken against the person to facilitate that we can go ahead and fish so that we don't take any action against us because it's offing. Now, although there is an order, no coercive action, a demand notice was issued to us for on 28/6/21, for which we filed 3496 of 21, assailing the demand notice. That is item 45.
Demand notice because you could not submit
Because
your case.
I'm not being able to pay.
You could not submit all or you did not submit any.
No. We could not submit in total, whatever was the dues, but we kept representing. They did not take action. We say, since there is no coercive action, kindly come to the operative area where we are allowed to fish, assess on that, and we'll pay up. Because we are not being able to pay, day one is our cost. No coercive action.
Okay, one thing.
My lordships.
Now supposing 100 rupees was what you were supposed to pay and you could not operate the entire fishery. Did you pay at least a part of it?
Yes. So we paid part of it. Now, there's an order of status quo at page 56, lordship may take up in this petition. 56.
Yes.
The operative part, at 57.
Yes.
57. Less this pattern on so and so, enabling Deputy Commissioner Dibrugarh, respond number 3, Circle Officer Dibrugarh West Revenue Circle, Dibrugarh, respond number 6, Circle Officer Dimo Revenue Circle, Assam, the missing autonomous council so and so, respond number 9, to apprise the court about the total area of the fishery, that is digging part 1 fishery, in length and breadth, and also state its area and further state the boundaries of the fishery that falls under missing autonomous council, including this. So total length and which part falls under the missing autonomous council, that was sought. And interim model was continued. That is the issue. Now, since missing autonomous council on its own had declared some fisheries within the boundary and proceeded to settle, we filed 6596.
That was when?
My lordships.
No. When did missing say that? When did they try to settle part of the fishery?
That was sometime in 21. Page 79 is the order.
Yes.
That is 6596 of 21. That's item 46. There was an interim mod operative at page 82. In the interim, until further order of the court, respondents in the missing autonomous council neither shall settle nor shall hand over possession
of any water body of 60% or 40% category of fishery department of the state of Assam, as well as Assam Fisheries Development Corporation that falls within the territorial jurisdiction of Fishing Autonomous Council, including part of said Dihing Part 1 fishery of Dibrugarh from Bekuri Chapuri to Titakuli Gaon of MSC, and further shall not disturb the fishing activity of the lessee with whom such water body is settled by the concerned authority, even though the entire area and or part of area of the water body falls under territorial jurisdiction of the said council. So this was being monitored by the Honorable Court when we were approached. At this point of time, there was the government, they proceeded to have a hearing of those persons which we have named by us, but somehow the hearing was not taking place and disturbances were going on. For this reason, we had filed WPC 3434 of 2022. That's item 47.
Page?
No, this is not page. 3434 of 22.
Correct, but there must have been an order.
No, this is continuing. There is no, they held the hearing. This is, difficulty is not there on the hearing part. Why we filed it? This is pending.
No, was any order passed?
Nothing.
No order passed.
No, because it is not affecting Noah's rights. Go ahead with that.
So notice of the issue.
Notice issue. Now, so far as again.
So issue is of a notice is an order.
Now, Fishing Autonomous Council again floated tender notice, for which we filed WPC 4562 of 2022. That is item 48.
Page?
I'm coming to this. 19/7/22 orders also. Become 4562, 19/7/22 orders. There's an interim order at page 19/7/22, which is not a part of this, of course. Anyways, now during the pendency of this,
Your document, your writ petition is incomplete. Very much
we have traversed everything.
No, you have traversed, but your documents
No,
are not
in
there to
second-
support your
second,
submission.
The order is there. We are not on that interim order for the present. Now.
No, you see, one thing is, how many,
This is the last one.
how many NITs did this issue?
Two.
The one has been challenged where?
One has been challenged is
In 4562?
656596, and the other 4562, where the order at 19/7 is reads. It is there, may not in the file. We pleaded that.
You see, the thing is that when you give us the dates.
I understand.
written, it becomes easier for us to pass an order so that the persons who read it,
I understand.
for you to, it's okay, it's in the back of your head. Now supposing I
I
pass
get
an order
I get the point.
and a division, somebody wants to challenge it before the division
I'm
bench.
so-
Then the division bench will straight away get to know. Otherwise they say, what is the single judge talking about? You can't make head or tail of what he's trying to say.
It's a part of the order. But now they had issued another demand notice, which is being challenged in 976 of 2023. This is at page 115. This notice is under challenge.
What is this demand notice?
This demand notice raises a demand of 39,23,998.
Page?
115. 115. Now, if my lord may have for a moment, 4562 of 2022, that is item 48 for a moment, the file. Item 48, 4562. 4465, I stand corrected.
4562.
465. 465. 465.
Yes.
19/7/22 there is an order. 19/7/22.
Yes.
The last part of it. Though on a close scrutiny, This court has found that there is no discernible pleading with regard to overlapping of the fisheries in question. Since the issue of jurisdiction is involved and apparently the Missing Autonomous Council lacks the jurisdiction to make such settlement, it is provided that no settlement or any other activity be made by Missing Autonomous Council which would have adverse effect on the fishing activities of the petitioner in the fishery duly settled with them. So the tender notice 7/7/2022 did not proceed that far. Now, so far as the Missing Autonomous Council is,
Just tell me one thing.
my lord.
Have you identified those persons who have been fishing?
Yes, yes.
Are they parties here?
They are not parties here. They are not parties here. We are on the action of the authorities. On one hand, though constant representations are being sent by us. On one hand, when this honorable court has directed, identify the boundary and the area which it falls. When your officers are admitting the facts, everything is done. Kindly do not saddle us with a revenue which we ought not to pay. We certainly should pay. Kindly assess that. Now, they have filed an affidavit in this writ petition 976, the government. The government has filed an affidavit. They are yet to do the exercise though, but they have filed an affidavit. Paragraph 9 and 14 would be relevant. If I may, this is an affidavit by the Joint Secretary, Government of Assam Fishery Department.
Where?
Paragraph 9. May I read?
Yes, yes.
That with regard to the statements within paragraph 8, 9, and 10 of the instant writ petition, the deponent begs to state that Missing Autonomous Council has no jurisdiction over any 60% or 40% government fisheries settled by government, DC, SDO, as the case may be, under the rules of 1213 of the Assam Fishery Rules 2053. The deponent further states that recently Missing Autonomous Council has moved government to parent Tribal Welfare Department for issue of clearance by government and Fishery Department for allowing Missing Autonomous Council to operate government fisheries in Missing Autonomous Council areas. The matter has already been clarified to all concerned, DC, SDO, civil, having areas under Missing Autonomous Council, stating that government has not transferred fishery as a subject to Missing Autonomous Council, and as such, the council has no jurisdiction as to settlement over 60%, 40% government fishery falling within council areas, either in full or in part, by letter number so and so and so. Now paragraph 14.
Yes.
That with regard to the statements within paragraph 16, 17, 18, and 19 of the instant writ petition, the deponent begs to state that missing people and Missing Autonomous Council in particular are illegally asserting their rights over areas of government fishery passing through notified area under MSC. The deponent further states that a number of districts having areas under MSC is facing same problem over such government fishery. In this connection, recent government instruction as stated in foregoing paragraph of this affidavit has already been issued to parent department of MSC to direct MSC authority not to take steps for settlement of government fishery under MSC in full or any part thereof, as well as refrain missing people residing in such areas from illegal fishing in such government fishery. My lordships, pausing for a moment, this honorable court also directed, carry out an exercise, get the entire picture of the fishery boundary and those within, check out what is the problem, get it sorted out. So far as jurisdiction of Missing Autonomous Council, that is nothing to do with this. We say that's a different writ petition, of course, whether they have the right or not. We say, so far as this ABCD is given to us, give it free. My lord, if I may submit, writ petitions can be disposed of, directing the authorities concerned. They also admit it is not the denial, there is no denial mode, but the work is not being done. That carry out an exercise within the time frame and compel us to pay whatever is due on the basis of actual possession what we are getting to fish. Not on the papers, on actual possession. There has been a direction from this court also to do it. For clarity and convenience, we have done that exercise on our part, which we may represent to them also. That lordship finds at page 22, paragraph 14. So far as our part is concerned, my lord, page 24, paragraph 15. Slightly long, if I may read it. That the petitioner states for clarity and convenience, the petitioner makes to indicate the length of the fishery from east to west, along with the length of the fishery under area of the missing autonomous council by mentioning relevant points, places, and relative distances between them. And so far we have indicated below, point to point. What we may do is that this paragraph 15 of the writ petition, paragraph 15 of the writ petition is our stand. This we may give to them. They may take a call on the field, what is happening, because they know it is happening, they admit it's happening, and then come out with a revised demand, what is to be paid. That is all, Milo.
You see, it is not the case of the respondents that they have settled the fishery with anybody.
No, they have not settled, but they admit interference.
They admit interference. So who has to, whose responsibility is it?
The deputy commissioner will say that the superintendent of police is
Or is
responsible.
it your responsibility?
Everyone, no, we have to intimate, we have been doing so. If from taking over possession, the day we taking over, next day this problem rise.
That is, let us see your agreement. What does it say?
My lordship.
What
Not
does your
every-
agreement say?
But agreement will be with the authorities, of course,
What does the settlement order say?
settlement order.
And unfortunately, you don't have the NIT also.
May I read the page
Because the
30?
terms and conditions of the NIT might throw some light.
Oh, no, this would not be on an NIT basis. I'll come to page 32. The one who defaulted and the second one comes in, my lord. Page 32.
Whatever, whether you come in the place of the defaulter or not, you take his place.
My lordship.
You become the settlement holder.
My lord, so far as the tall and short of the writ petition is that when you admit interference and we have complained at the first point of time till date, kindly have a look in their matter. Kindly reassess on the basis of actual possession and raise a demand. That's what we are on, nothing more than that. And they also say there is nothing, there is no stay order not to pay or don't raise. But everyone is admitting the fact that difficulties are there. The
How
problem,
much, how much was your bid amount?
my lordships,
How much was your bid amount?
that is settled amount is 22,61,999 for 7 years.
2261.
999 per annum for 7 years.
999.
For 7 years.
22,61,000.
That's per year.
So 22,61,999. You are supposed to pay every month.
Every year.
Every year.
Every year.
For 7 years.
7 years.
So it comes to
Total
more,
1 crore 58 lakhs
1 crore 58 lakh
33,993
33,993
for the 7 years.
for 7 years.
We are not on disputing that.
No, no. How much have you paid now?
I have to take the actual call because till now, in bits and pieces they are paying. I do not know what they have paid.
So according to you, how much percentage of the fishery have you been
We say-
operating?
We have made a statement. 25 kilometers or yes, page 26 of the writ petition.
Yes.
We have said calculating the distance as kilometers, it will be 2.5 plus 14.so. Total 21.74 kilometers. The petitioner had calculated petitioner distance to be 25, roughly 25 kilometers,
25 kilometers.
roughly.
And what about the breadth?
No, we have said this is,
This is for the length.
this is are not allowing us to operate. And this is the main area which we are saying,
They're not allowing you to operate in this
25 kilometers.
25 kilometer
And
area.
that direction was them for them to them. That kindly indicate the total breadth, the missing opulence content, what difficulties are there, that is not coming on record. This part. So let them carry out the exercise, my lord, and then raise a demand. That's all. They are not against us. Government is not against us in
Let
this.
us see.
Lordship, before I start, Lordship, kindly go to two writ petitions and fine, Lordship, 976, Lordship. 976, they are prayer portion, then they are asking for remission of that part, Lordship. And just remain. And
The prayer,
in page number 28, 976.
26. Yes.
Here, Lordship, in
Prayer number B, the respondent authorities to recalculate the KIST money on the basis of the total area of the fishery in length and breadth and subtracting the area and boundaries of the said fishery that falls under the Missing Autonomous Council. By this prayer, they are giving authority to the Missing Autonomous Council. No, as per this prayer, request. Kindly go to petition number 4652, Lordship. 4652. To contradict 4652, Lordship. And directly moving. 46. Page number.
4652,
Page number 12, Lordship.
page number 12.
Yes, Lord. I'm reading, Lordship. The fishery in context is a 60% category fishery having definite boundaries. Creation of such fishery is in terms of procedure as prescribed in Assam Levy and Land and Revenue Regulation 1886. The procedure for settlement is 60% fishery is prescribed in Assam Fishery Rules 1953. No authority in law has the jurisdiction to declare a water body falling within the boundaries of the 60% category fishery to be an independent and separate fishery. Missing Autonomous Council does not have any jurisdiction to offer settlement of any water body falling within the boundaries of a 60% category fishery. Dahing Part 1 fishery from Bekim and Upper Purgatory is so settled earlier by Missing Autonomous Council by unilaterally declaring a water body within the boundaries of Dahing Part 1 fishery is actually a Part 1 of Dahing fishery. Has a period of settlement the said is over and stated that Missing Autonomous has again settled the said fishery and declared a water body within the boundary of Dahing Part 1 fishery to be a separate fishery and settle the same. That as owing to the disturbance from persons from the areas within the Missing Autonomous Council, the members of the petitioner society cannot carry out fishing activities, collect fishery revenue from within the boundary of the Dahing Part. Lordship, Lordship, in this petition, next petition, he is saying the petitioner is saying that Missing Autonomous Council has no right to settle anything. Now there is no, I'm against that. There is no question of boundary, no notifying boundary, because for that, Lordship, fishery rules has to be amended, Lordship. Fishery rules are not amended, and for Missing Autonomous Council has not given the executive power also. That part is there, Lordship. Here we have given the settlement, Lordship. That is absolutely correct. Here the disturbance is from MSC. MSC has given the settlement. If MSC has given the settlement, MSC Principal Secretary has given the settlement. The losses he incurred from the MSC, the NIT issued by the Principal Secretary MSC, Lordship, not by us, Lordship. Here, yes, Lordship, MSC. Here I am against.
No. That's not what he's saying. He's saying that earlier it was settled. Now it's not settled.
Not settled. 1972-2022, the order. No settlement was made. We say persons, the two.
No, here, Lordship, here
Is
is to
basically-
recalculate the KIST money, Lordship.
Correct.
KIST money.
Yes, sir.
KIST money, Lordship. How can this in the earlier petition, he is asking for recalculating the KIST money by notifying the boundary of the MSC. If we notify, if we give them even or that we are excluding the MSC area, it will be against Lordship. I'm giving the right, Lordship.
No, he doesn't want that, you know.
Lordship, page number 28, Lordship. Kindly go through it.
Page number
28 of the this petition, Lordship.
20.
976. Kindly go through it.
28, yes.
The respondent authorities to recalculate the KIST money on the basis of the total area of the fishery in length and breadth.
Oh, subtracting the area. No, there's no question of subtracting the area.
No, what we are saying is in consonance with page 56, 57 order. We say we cannot operate the area which falls under them regardless of settlement. The disturbance is going on. You don't take a call. Then subtract that area portion and then calculate the
He
KIST.
will go against this in his own writ petition. His statement is going and he's in this writ petition in a 465. He is saying that
would
MSC has no right. And
I would
now he is
clarify.
asking for subtracting that.
But I will clarify that. That part which my friend has read, I'll clarify that. So far as the 4652 is concerned, that was assailing the jurisdiction of the Missing Autonomous Council in issuing a tender, which was 772022, which was recognized to be bad by this honorable court and said that there should be no settlement or any other activity by the Missing Autonomous Council. That is so far as that particular tender is concerned. I say you cannot settle because what you are doing is you're creating a fishery within our water body.
No, but then how can you pray?
Absolutely.
How
I'll come to that. Now, so far as page 56, 58 is concerned, 56, 57 is concerned, I'll take it straight away, my lordship. 60. Time and again, 57. 57. Yes, 57.
57?
57 of this writ petition. 976, page 57. Initially, we had said these persons are there who are creating problems. We named them. Thereafter, when there was settlement, move effort for settlement, which challenged the jurisdiction basis of settlement, that was stayed. They did not settle. The problem is accepted by them and they file an affidavit. Yes, there are problems.
No, you see, one thing, you see, now, the issue is how much of the area have you not been able to
25
operate?
kilometers.
Huh?
25 kilometers.
No, that means the area and the entire area under the missing autonomous council, is it?
No, it's not. Fishery is large. 25 kilometers, we have not been able to.
Then why do you want that the area under the missing autonomous council should be?
This is the stretch where the problem is being met with the petitioner council, petitioner society. This is the stretch.
What is the area within the missing autonomous council?
That is the order passed by the Honorable Court directly.
No, Mr. Council, I am asking you that.
My lordships,
What is the area,
my lordships,
the length of the fishery within the missing autonomous council?
25 kilometers.
25 only, not more than that.
Not more than that. Might be slightly less also.
So that missing autonomous council area, you have not been able to fish.
Absolutely.
Where is it? Let us see your representations. Let us see your representation.
And as also the order, there was an order from
the orders, we forget the orders, that we can always correct here and there. We have to see what is your prayer in your representation.
Page 36.
Okay. Page 36. Port ship 1976. There is.
We have not said which area.
No, we have
some.
We have only said that they have obstructed.
My lord, is obstruction. One of my friends supporting me, the government is supporting me in this case. They are not against. That's for the sake of objection. The objection should not be on record.
I'm supporting in the matter of that objection.
Correct. What we are saying is that over the time, that was in 2020, and therefore the writ petitions came. We elaborated in pleadings, my lord. A direction was there for them to look into the matter.
What is in the pen?
I want to see what was your prayer earlier.
If even my affidavit in reply, my lord, at page 104, in 3434, I've elaborated when the proceedings are going on. They are aware of it, my lord.
Nowhere have you said that the fishery within the council area could not be operated by you. You have not said
No,
where.
it's not about the council area. 25 kilometer stretch where the persons from the missing autonomous council area are disturbing. It's a matter of coincidence that those 25 kilometers is the stretch falling under the territorial jurisdiction of the missing autonomous council. We have been bold enough to stay on record, my lord. We have also filed additional affidavit in different cases. It's on this context, it's Honorable Court directed. Let us have a picture of that. My lord.
Let me see now.
The page 36, lordship, there is obstructed collection.
Correct.
Fishery per revenue, there is a name of around 10 people, 10% lordship. So I think these persons also should be made party lordship while filing the application. And here aspect is that lordship, I am.
They are not taking action on that.
No, lordship.
Just a minute, Mr. Council, he has not disturbed you while you are making submission. Yes.
Yeah, lordship. We are, my only concern is that lordship, by rest I living lordship, if lordship, this prayer portion subtracting lordship, if we allow this prayer.
No, that we cannot. You see, it is not his case, in his representation, that the fishery within the missing autonomous council has not been operable, has not been operated by them. That is not their case. They are only saying that they have been obstructed by some missing person. So that's the only thing. There is nothing with regard to,
Nowhere stated, Lord.
there's nothing with regard to council area or non-council area.
Yes,
That's
sir.
not-
Even if we have stated and treated
Just a minute, Mr. Council, I'm talking to him.
Lord, here, Lordship, nowhere he has stated, Lord, here I am reading the representation. Respectfully, it stated the government of Assam has settled being part one. We have admitted also. Settled being part one fishery with a cooperative society from so and so years as a regular settlement. Accordingly, in our fish selling centers, it is only in fish selling centers. Bihingmung Fish Selling Center, Lalbil Fish Selling Center, Pans Gorilla Fish Selling Center, Hekuri Sapura Fish Selling Center, Sesamu Fish Selling Center, we had gone for revenue collection. That means while going after collecting the fish from the river, they went for selling them. At that point of time, some persons from missing autonomous council had obstructed our fishery.
Mohoris.
Mohoris.
What does that mean? Mohoris?
Mohori means advocate clerks, like advocate clerks. They are also
Huh?
that they are appointed clerks.
Okay.
Appointed clerks like this.
So there was no obstruction to fishing,
Fishing.
only with respect to the collection of the revenue, the sale
Revenue.
proceeds.
Yes, Lord.
This is a completely different issue.
my lordships, entire difficulty is there with their affidavits also stating that it is not that we have made some vague statements. Page 75 of the writ petition may kindly be noticed once, my lord. Page 70 of the writ petition. The government is not against us, but now they are saying that no, we don't have nothing, we have nothing to do. You pay full. Whatever happening,
You
happens.
see, Mr. Council, I am going only with your
I
representation.
understand.
Your
Page 75.
representation nowhere says that anyone had obstructed you from fishing.
Even Lordship, I was just reading.
Page
it.
75.
My name is reflected, Lord. At that moment, I was not the council, Lordship.
Page 75.
Yeah.
This is from the SP Dibrugarh to the DC Dibrugarh. Mary. Sir, with reference to the subject cited above, I have the honor to inform you that on receipt of the complaint petition 5121 submitted by Sri Prafulla Hazarika, Secretary MS Dihing Part 1 Fishery Cooperative Society Limited Dibrugarh, from your end, OC Borborua PS conducted an inquiry and investigation is going on the petition filed by the petitioner. However, to proceed further with the process of investigation and take necessary steps to prevent any untoward incident between two parties before the Honorable Court's judgment, the following point needs to be asserted. Whether both the parties as missing Dehing Part 1 Fishery Cooperative Society Limited Dibrugarh and missing Autonomous Council are to be allowed to collect revenue from
Are to be allowed to collect revenue.
from the fishermen.
Correct. So this is not a question of you being not allowed to fish. It is with regard to collecting revenue from the fishermen.
Yes, Lordship.
Which
Yeah.
And which party has the legal authority to collect the revenue? It's not about you not being allowed to
Lordship,
fish.
my lord, yeah, this is like this. In Uzan Bazar also, there is some people cart also. That is called Mohori. That people used to sit, Lordship.
Ah,
That is
yes. Yes.
Paragraph 14 of the affidavit also states the same thing. Tall and short of it is that they are asserting rights over the period fish and settle with us.
It is with regard to collection of revenue at the end of the day. It's not with regard to fishing. No, this is the document you are relying upon doesn't favor you.
My lordships, the
Yeah.
entire fact is that they also say the government
So
says.
you see, whether they are supposed to collect the revenue, or you are supposed to collect the revenue, that's a different issue.
My lord, entire problem is with the fishing, with the operational area of the fishing. We're not being given the area to fish. And therefore, in the writ petition also, they have not come up with the direction by the Honorable Court. Kindly see to that, my lord. Page 22, paragraph 14. Prior to that, I'll take page 21, paragraph 13. I'm on page 23 of the writ petition. Page 23.
Yes,
Page 22 also last part is same.
yeah.
Paragraph 14, may I read? Page 22 last part. Paragraph 14. That the petitioner states that as per joint verification report of the circle officer Dibrugarh West Revenue Circle, letter number so and so and letter number so and so issued by District Fishery Development Officer Dibrugarh, the following information can be ascertained. My lord. From east to west, the length of digging part 1 fishery is so and so, 38.99. From Old Bridge to so and so, this is the given mirror in hectares. The fishery area under Missing Autonomous Council extends so and so, so and so. It is given. It has been reported by the District Fishery Development Officer Dibrugarh that the most productive area falls under the fishery occupied by the Missing Autonomous Council.
Area.
Yes,
Okay.
the secretary of the, may I just go on? The secretary of the petitioner society had personally visited office of the additional deputy commissioner revenue once Dibrugarh on 15/2/23 and had sought information to meet the query of the Honorable High Court when order to the 10/11/21 passed in WBC so and so. Although the secretary of the society had submitted an application in the said office on 15/2 seeking such information, yet copies of these documents were not handed over to the secretary of the society. However, the secretary of the petitioner society was allowed to see such documents only, and after much request, the details could be noted. There's an order of this honorable court initially, my lord, with regard to these documents. They say the productive area falls there with nothing to do, my lord. This backdrop, my lord, that orders were passed.
Okay. Anything else? So what is your case, Mr. Sharma? Yes,
Regarding the present status.
huh?
Actually, I'm just going through this now, Lordship. Actually, these matters were old matters, Lordship. How my name came, Lordship? I'm going through it and I'm submitting, Lordship. Right now.
Are they submit?
That's why I submitted, Lordship, what I have to say, Lordship. Regarding one thing, Lordship, here all things are contradictory, Lordship. In one sense, he is asking for subtracting that is revenue by deducting the MSC area. In another way, he is saying the MSC has no right.
Has no?
Has no right to settle. All falls under the government of India. Lordship, my basic concern within in this area, Lordship, my only thing is that MSC has no right and MSC cannot do anything, Lordship. As per that notification also, my learned friend has enlightened that notification. In 2017 notification, Lordship. MSC does not have any in Oxbow anything in water bodies also.
Absolutely correct.
And no, MSC has no right, Lordship.
But
here, Lordship, if we give any right, if we subtract any area from the MSC area, that means we are giving right.
No, he also correct therein. My lord, 3 documents they may produce, my lord. This is Lordship has heard the entire matter.
Lordship, if we
3 documents may produce.
Positive point. Lordship, if we say that is our concern, but the others I leave it to Lordship. By concerning that part, Lordship may pass order.
What?
By concerning that, my concern, Lordship.
Your concern
regarding MSC area.
And my lord, I was only referring to 3 documents at page 22, which I referred. And the order of the honorable court also directing them. Lordship has heard the matter in length. It may be heard in part, kept heard in part. Take up next week, any date Lordship takes up. Those 3 documents only.
What document?
14, 4, 12, 21, 10, 12, page 22 if indicated, which is absolutely in my favor. Their document, inquiry report document, may know, which they are not placing on record. But this is a sheet anchor. The inquiry was conducted.
You all asked for final hearing. I have heard.
Absolutely,
I'm going to dispose of today.
They have the document.
I'll dispose it of today. Why should I wait?
These documents are the sheet anchor of the case where they should have had the records of this minute.
Why didn't you Why didn't you say that before I heard?
No, I did not know whether he would say that I am importing new, I do not have
Huh?
documents. That I could not see through me, Lord.
What?
That my friend would make a submission that he is appointed subsequently, he doesn't have the record. That I could not see.
No, that is
no
not the
order for
issue.
it.
That, you see, first of all, you also have not put the
NIT.
contract agreement. The agreement, there must have been an agreement signed.
Yes, sir, and.
The NIT also nothing. But you
Of
said
course.
that's not, you didn't
That's
find it
not
that
so
important. So I
in-
said, okay, take it. You wanted to dispose of, now when I'm going to dispose of, you
No,
take a
Lord,
U-turn.
you may take note of paragraph 14 of my writ petition.
Okay. Whatever, right. Heard Mr. S. Bani. Learned counsel for the petition. And Mr. P. Sharma for the
Fishery department.
fishery department.
There is several
Ms. Udas appears for,
My lord, other respondents, my lord.
other respondents.
My lord, I'll have to check, my lord, in which and I don't.
In other government respondents will be better also. There are several respondents named different days.
okay, for the other government response. Okay, you are there also,
Mr.
Yes, what up?
Officer.
On behalf of it.
Mr.
Yes, what up? Name.
Mr. S. Bhattakur appears for the missing autonomous car. Yes, Ms. Das, anything to say?
Because only this is not, fishing was not my lord, bar. They could have only for collection of revenue, my lord.
Okay, right. The petitioner is aggrieved by the demand notice made upon the petitioner for payment of kist money. Please hear the facts. Okay, because I might be wrong, so please correct me. Sir, what have I said? Demand notice for payment of kist money. Yeah. 43 to 48.
976.
For payment of kist money on the ground that the petitioner has not been able to operate the entire taking part one fishery. Since the time the same was given in possession to the petitioner, that is on 10/12/2020. He accordingly praised that a direction should be issued to the respondent to
Page 28.
make a verification report with regard to the total area of fishery minus the area falling under the missing autonomous council and to recalculate the kist money payable by the petitioner. Next paragraph. The petitioner's case in brief is that in pursuant to a tender notice, comma, the petitioner was settled. A settlement order was issued on 18/11/2020, settling the Dehing Part 1 fishery with the petitioner for a period of 7 years at rupees 1,58,33,993, which was at the rate of rupees 22,61,999 per annum, with effect from 5/12/2020. The possession can be 10/12.
Lordships.
You said possession was at 10-12, but then this,
Lordship sees the order at page 35.
it says what?
Certificate of handing over is 10-12. The
Okay,
order
but,
is there.
but from 5-12, it has to be counted. Full stop. Anyway, full stop. The petitioner's further case is that after taking possession of the fishery, there was continuous disturbance caused by persons from the members of the missing autonomous council area. Which resulted in the members of the petitioner society not being allowed to fish within parts of the Dehing Part 1 fishery, and also not being allowed to collect any fishery revenue, is it?
Lordship. You should not laugh.
No, because that was not their submission. That was not their submission.
And so far as I just
The collection part you cut.
In MSC matter, we are supporting each other.
Huh?
In MSC matter, we are supporting each other.
And you cut that, and part you cut. That is not made submission. The next paragraph, the petition council submits that the said issue was brought to the notice of the authorities by representations, two representations dated 11-12-2020. Issued to the circle officer and the OC of the officer in charge of the Netaji police station.
Netai.
Huh? Netai. Actually, the circle officer will be Demo Revenue Circle, DMOW. huh? Thereafter, the petitioner submitted two representations dated 15-12-20. No. Thereafter, the petition submitted representation dated 15-12-2020 to the DC Dubriga and representation dated 15-1-2021 to the the DC Dubriga will be two representations, 15-12-2020 and 15-1-2020.
But I believe I should indicate one thing before Lordship dismisses the petitions.
Huh?
That will be easier. I should indicate one thing as an officer of the court, of course. Whenever a particular society is settled with any fishery, it is not the absolute right of the fishery members to fish. Even the missing people can fish. Even anyone can fish. Even I can fish. But within the area so settled, I have to sell the fish at the fishing counters and collection of revenue would be from here. From here, I have to pay the kiss money. If everything is admitted, the collection of fishery revenue was been obstructed and therefore natural corollary is I cannot pay the revenue. Different issue, who is fishing in the water. If I cannot collect the revenue, I cannot pay. That much everyone is admitted. I just pointed out. That is how the fishery operates.
I must clarify one thing, Lordship. Here he is saying that missing people can fish. That is not true. Because only the SC community and Maimal community of Kasa district can fish.
No, SC also can fish by the fishery rules. Even I can fish. That's not a problem. The problem is.
No, let us not change.
No, I'm just indicating because if I could read, my lord, that fishing is one activity. If a person fishes to eat, no problem, to consume. But the moment he says at the fishing counter, collection of revenue, if that.
I am only going by your representation. I am not going beyond that.
No, it's one and the same. If I could.
No, it's not one and the same, because your entire case is that you're not allowed to fish. Your entire case was you're not allowed to fish. Your representation say otherwise.
Yeah,
And the police report says otherwise, which you had relied upon. So that is a different issue, where just because someone has been collecting the revenue and not paying you the revenue, that's a different issue. That does not amount to not allow you to fish.
But if I cannot collect the revenue, I cannot pay the Kist money.
That is a different issue. That is not what your case was about.
Different-
All
different-
along, you have been referring to the court orders and this orders, all relying upon. They should be measured, the fishery should be measured, should be 25 kilometers.
But this is orders of this honorable court.
But that is on the basis of your submissions.
I agree with you.
Maybe they did not read their representations properly. Right, so where am I? To the deputy commissioner. Just a minute. In all the representations. No. As the petitioners, as the representations of the petitioner were not being considered by the township farmer. The petitioner filed WPC number 783 of 2021. Praying to the with a prayer to the deputy commissioner, with a prayer to issue a direction to the deputy commissioner Dibrugarh and the superintendent of police Dibrugarh to stop the illegal fishing occurring within Dehing Part 1 fishery
Collection of revenue, Lordship.
and to ensure that members of the petitioner society were not stopped from collection of fishery revenue. A further prayer was made for a direction to the deputy commissioner Dibrugarh not to demand payment of revenue from the petitioner society until the petitioner society was allowed to operate the Dehing Part 1 fishery peacefully and was allowed to collect fishery revenue.
One minute.
In the second writ petition that you filed, was there any NIT issued by the MAC? No.
Demand notice 28/6/21.
No, in the second writ petition.
496.
It says 6596.
6196 are said. 7 orders no. Soft copy 7. Yes. 77202. In those ordering. Get a sound. Soft copy is order. Not a division. 4652. Lordship is referring to my lord.
6596 2021. There's nothing out here. Right.
Lordship, there is a order. Lordship, then no in 6596, Lordship. There is a 69, page number 69, Lordship. Kindly go through. No NIT, but they have given direction. 69. 6596.
Okay, right. Next para. Subsequent to the above, comma, the above events, comma, the Deputy Commissioner Dibrugarh wrote a letter dated 28/8/2020 to the Joint Secretary to the Government of Assam, comma, Fishery Department, stating that the Principal Secretary, comma, Missing Autonomous Council, comma, hereinafter referred to as MAC, comma, had given settlement of the Dehing River Part 1 from Bekuri Chapor Parghat to Tetteliguri Gauni in favor of one Sri Sibha Bhuyan, comma, Secretary, comma, MS Dehing Nadi Pachi Manchal Anchalik MSS Limited. Full stop. As the order of the Principal Secretary, comma, MAC overlapped with the fisheries belonging to 60% category of fisheries settled by the Fishery Department, comma, Government of Assam, comma. The Principal Secretary MAC was requested to withdraw the order issued settling the fishery with somebody else other than the petitioner, settling the petitioner with somebody else. Full stop. The said, no, in view of the letter dated 28/8/2020 issued by the Deputy Commissioner Dibrugarh, comma, the petitioner filed WPC number 6596/2021, praying that writ in the nature of mandamus should be issued, directing the MAC not to declare and settle any water body within the boundaries of any 60% category fishery, comma, 40% category fishery, or a fishery under the jurisdiction of the Assam Fisheries Development Corporation as a, and full stop.
This is wrongly typed.
Under the Assam Fishery Department.
No, it is a department, it should have been.
Assam Fishery Department. Full stop.
Corporation for this.
This court,
Correct.
Huh?
Either by the state government or by AFDC, correct?
so it should be Fishery Department.
No, Assam Fishery Development Corporation. He represents that also.
Okay, no, it's not that. But then who has settled you the fishery?
No.
Who
For
settled?
the government,
Huh?
government.
Then
No, we have to sort it.
Okay, over here.
full stop. This court, by order dated 9/12/2021, passed in the WPC number 6596/2021. Passed an interim order directing the respondents in the MAC, directing the MAC not to settle or hand over possession of any water body of 60%/40% category of fishery of the state. Full stop. Next, full stop. It may be stated, it may be stated here that the Dehing Part 1 fishery is a 60% category fishery. Correct. And the same had been settled with the petitioner by the Assam Fishery Department. Full stop. Let's go one by one. 6596 goes. Then we go to.
He has done it.
Huh?
Great job, he has written, drafted.
No, he's getting paid for it.
Yeah,
Why not? The more the merrier.
more than million.
Next para.
Lordship may also produce page 83 of the writ petition.
No, 82, 80.
No, I'm on 83 of the 976 writ petition, which is their stand.
Just a minute, one by one,
Whenever,
one by one.
Whenever.
The petitioner thereafter filed WPC 3434/2022, stating that the petitioner had brought to the notice of the authorities that fishing activity in the Dehing Part 1 fishery, which fell within the territorial jurisdiction of the MAC. Now, what have I said? Stating that there were obstructions. No, there were obstructions in the fishing activities. The obstructions faced by the petitioner society in the Dehing Part 1 fishery area under the territorial jurisdiction of the MAC. Yes, sir. Thereafter, in view of the thereafter, thereafter, to discuss the problems faced by the petitioner society, a meeting had been fixed by the Circle Officer Dibrugarh Dibrugarh West Revenue Circle on 25 to 2022. Not a meeting, a hearing was fixed on 25 to 2022, wherein the petitioner was required to be present. Full stop. However, as the hearing was not conducted by the respondent authority on the said date, that is 25 to 2022. The petitioner made a prayer in WPC 3434 of 2022 for a direction to be issued to the circle officer, Dibrugarh West Revenue Circle, to conduct a hearing as had been notified by notice dated 15 to 2022. Yes. Yes. Next para. Subsequent to the filing of WPC 3434 of 2022, the petitioner filed no, the respondents, the demand notice issued by whom?
This last one. Present one is additional.
3496, we have made a challenge.
3496, same.
You have challenged the demand notice.
2021 issued by Additional Deputy Commissioner R. Dibrugarh.
Okay. A demand notice dated 28/6/2021 was issued by the Additional Deputy Commissioner R. Dibrugarh, directing the petitioner to deposit
9,31,000.
9,31,00, which was the area dues payable by the petitioner. The petitioner challenged the demand notice on the ground that though the boundaries of the said fishery had been demarcated, but due to encroachment by the purported fishery settled by the MAC to other settlement holders, there were obstruction in the fishing operation conducted by the members of the petitioner society. As such, in view of the obstructions faced by the petitioner society, the demand notice demanding rupees 9,31,000 was nothing short of coercive measures being faced by the petitioner for payment of money when the petitioner society could not operate the entire fishery. Next part. The petitioner thereafter issued, no, sir, file WPC 4652 2022. No, don't say that. No, don't say that, cut that, just say. Thereafter, the missing autonomous council, bracket MAC, issued tender notice dated 7/7/22. Whereby the Dihing River Part One fishery, which had been settled with the petitioner, was sought to be settled by the MAC. Pustak. The same was put to challenge by the petitioner by WPC number 4652/2022. This court by order dated 19/7/22. It passed in 4652/2022. Thereafter, passed an interim order that no settlement or any activity should be made by the MAC, which would have which would have an adverse effect on the fishing activity of the petitioner in the fishery duly settled with the petition. As the MAC lacked the jurisdiction to make any such settlements. Gustav.
Now the demand notice.
Huh?
Now the present demand.
Yes. The petitioner there has thereafter filed the present writ, but has thereafter filed WPC number 976 of 2023 on the ground that the area of operation of the petitioner's fisheries on the ground that the petitioner has faced the members of the petition society has faced obstructions in fishing in parts of the Dehing Part 1 fishery. As settlement was illegally given by the missing autonomous council. The further grievance of the petitioner is that instead of redressing the grievance expressed by the petitioner for removal of obstruction and to enable the petitioner and to enable the members of the petitioner society to conduct free fishing without any obstruction, a demand notice had been issued by the state respondents for an amount of rupees 39,23,999. The petitioner thereafter made the following two prayers. That is to set aside the demand notice dated 10/1/2023, wherein the petitioner has been asked to pay kist money of rupees 39,23,998 and to recalculate the kist money on the basis of the total area of the fishery of the Dehing Part 1 fishery in length and breadth, after subtracting the area of the fishery that fell under the MAC.
If actually please to
Huh?
page 83, which I'm adding on now. 83 in paragraph 14. This may be recorded before. 83. May I read 83?
Just a minute.
The stand of the Joint Secretary Fishery Department. The last paragraph.
Also is going to 976 petition.
Huh?
Also is going to which
976, the last, the first that 976 of 2023.
43.
22. Which one is
In view of the above.
relying on 83? Is
Next para, the petitioner's counsel submits that this is all right. This is not with regard to boundary area.
No, we are not that-
I'm going to reflect this. Don't worry.
Yes, that's.
I'll reflect that. Yes, I'm reflecting.
It says that if I cannot collect revenue, I cannot pay. That's the
No,
statement.
no, that is a different thing. But then your prayer regarding you not being allowed to fish, that is nowhere indicated in any of your
any official documents also?
Huh?
In
In nothing, nowhere, in none of the, even I think the affidavit of the state government in one of the writ petitions does not talk about that.
Document my friend is relying 83. Is not saying anything about.
No, it says.
Next, okay, right.
Cautionary.
Mr. P. Sharma, the learned counsel for the Fishery Department, Government of Assam, submits
Submits that
submits that the representations of the
regarding
the petitioner and the stand taken by the respondents
is not in tune with the.
clearly goes to show that the grievance of the petitioner is not related to any obstruction in the fishing activities or in the fishing activities in the Dehing Part 1 fishery. Full stop. It only relates to the obstruction
Made by certain person.
allegedly made by some persons
Who are not a part.
with regard to collection of sale proceeds of the fishing by the petition. Full stop. Accordingly, there is no requirement of measuring the area of the fishery. Especially when it has been clearly been held. It has been, especially when it has been held by
What's expect the years stated, page number 12. Yep. 4632 page
just
number.
a minute. It has been clearly held by this court in the order dated 19/7/22 passed in WPC 4652/22 that the MAC apparently lacks the jurisdiction to make settlement of a fishery.
He's saying that
Huh?
he's saying that it will be helpful in our case, Lord, where
Correct.
we are supporting each other.
No, this is your submission. This is not my submission. I could have made it, but this is your submission. Yeah, there are little. Huh?
Paragraph 14 and page 83 may be indicated, my submissions
Paragraph 14
of the
and
writ
83.
petition. Of the writ petition and page
You
8.
see, from what transpired from all this, there's no question of measurement required. Only question is with regard to collection of revenue. So that they can look into that. Whether
But if I
the,
cannot collect revenue, so I cannot pay, that the.
you can collect, you can fish, you cannot collect revenue. It is not that you have been, there is obstruction in your fishing as per your representation. Your representation nowhere states that you have not been allowed to
Lordship
fish.
sees it from the end result. If I cannot collect revenue, so I cannot pay. I put it to myself. And that is 83. 83 is the fishery department's stand. I am not on anything else. 83 is the
Okay, so a person who is settled with the
if
fishery,
he cannot collect revenue,
so
cannot pay.
his job is only to collect revenue.
absolutely.
It's not a question of pay, it's not a question of fishing over.
No, fishing can be done by all.
Hmm.
His rights are to collect the revenue and pay.
Also, I don't know.
Huh?
I don't know this proposition.
No, I know absolutely clear on the law.
Lordship,
I'm absolutely clear on the
here,
law.
Lordship, one more thing, Lordship. In another petition, there is a stay, Lordship. There is a stay operating, Lordship. If somebody has violated, Lordship, it is a missing autonomous council principle, he could have filed a contempt petition. And here, Lordship, in my opinion, Lordship, here the government revenue is at stake, Lordship. Assam Business Executive Rules to.
Anyway, the question of measuring a fishery does not arise. That is not a question at all.
But if Lordship.
You are harping on, where is that order where you are harping on that this court had directed that it should be calculated. I have to
56.
clarify that.
56.
In which writ petition?
That is, my lord, at in 3496.
Just right, huh? Mr. Banik,
Fishing is
the
not
learned counsel for the petitioner submits in that when 3496, huh? In 3496. Submits that. Where is that? Where is that?
3496.
I think this is Pathak's order.
Page 56.
Huh?
Page 56. 3496. 3496.
Yeah, 3496, there is only up to 52.
Page 56.
It's only after 52, Lordship. Yeah, we got it. In the second of Lordship.
No, not just a minute. No.
Page 56, Lordship says.
In which writ petition?
3496. No, Lordship gets the order in.
I want the order passed by this court.
Absolutely,
Interim order, yes.
In 976, it's page number 56.
Oh, 976.
Tell this.
In that 3496, huh?
Right.
You are right. In this court passed order dated 10/11/2021 in WPC 3496/2021 as follows. You just take down this, huh? At page
It is already
57.
not direction, it's enabling, Lordship.
I know. I just want to show that how it came about this order. That's why I'm recording it.
Well,
I have to clarify.
one thing, Lordship, I want to praise, Lordship. Whether it is required or not, I don't know. Here, Lordship, all problem arises out of the principal secretary issued by that person, Lordship. Principal secretary missing autonomous council. Actually, law should be, they should have gone for.
No, I'm not on that. You see, collection of revenue, whether he's unable to do that or not, I think you should look into it. But the question of measuring the fishery does not arise, because there is no question of anyone stopping anyone from fishing.
That's it.
It is clear from here.
There-
There's nothing stopping anyone from fishing. His only problem is that he's not been allowed to collect his thing. Anyone is allowed, anyone, he's saying that anyone can go fishing. If anyone goes fishing, then where's the question of measuring how big the area is? Because that's not an issue.
One thing, Lordship, if also, Lordship, I am okay, there is no question of measuring the fishery, Lordship, but here, Lordship, that right is also not there. It's a missing autonomous council. We cannot measure also, Lordship, because missing autonomous council in the notified area. Lordship.
No, we are not saying whether missing autonomous council has got any right. They have got no right already. There is a observation made. But leaving that aside, the issue is not with regard to measuring. The issue is with regard to his inability to collect
Revenue.
the revenue. Because the persons who have fished are not giving him revenue. That is what is. The person who have fished, those MAC person, whoever, those 10%, are not giving him the revenue. That is the issue.
There is also one person, the person who is being entrusted by him.
I do not know. That is but there's no question of thing. The thing is that the person who have fished are not giving him. That's all. That's why he's named them also. Otherwise, some
They are
person.
obstructing.
Huh?
Fishing is done by random. So if I cannot collect revenue. I
So
collect obstructing.
the issue is,
Correct, got
so
it,
if you're not able to collect revenue, what is the purpose of asking someone to go and measure how big the fishery is?
Yeah.
Where is the connection? I fail to understand.
But there is a pronounced silence by the authorities, although.
Mr. Kaushal, you are very smart. You know exactly what you want. Yeah. I think you know exactly what you want. I don't know, future, something. You still got another few years to go. But 2020 till 27. Anyway, right. So where are we? Then you also like, he further submits that when the entire problem of the petitioner society is only with regard to collection of, with regard to his inability to collect revenue, full revenue from the person who have fished in the said fishery area. There is no requirement. There is no relevant, there is no need, there is no requirement for measuring the area of the fishery. As it is not the case of the petitioner that they have not been allowed to fish. So it is only a case of some persons who have not been given, some persons allegedly not giving their fee, what do you call it? Revenue. Kiss money.
No,
No.
not allowing the petitioners to collect revenue.
They're not allowing the petitioners to collect revenue after having fished in the said fishery area.
Which is a disputed factor.
Anyway, I said alleged. That's why. Good stuff. Next. So that's it.
That's it, Lordship.
I have heard the learned causes for the parties. Good stuff. A perusal of the 4 representations made by the petitioner on 11/12/2020, 15/12/2020 and 15/1/2021 show that the petitioner society's agents had been obstructed from revenue collection by some persons belonging to the MAC area. It is not the case of the petitioner in any of the four representations that that the members of the petitioner society were obstructed from fishing in the Dehing Part 1 fishery. The prayer of the petitioner in all their representations is that necessary action should be taken against the 10 mentioned persons in their representations so that the petitioner society could collect revenue. First off, the names of the 10 persons against whom the petitioner society has alleged that has alleged the names of the 10 persons who have the tens of the alleged 10 persons who have allegedly obstructed the petitioner from collecting their revenue are reproduced below herein as follows. Page 33, Annexure F of WPC 6596 of 2021. Don't say that. Instead of that, you just write. Instead of that, you write. The representations are all similar. The four representations are all similar. And the representation dated 15/12/2020 issued to the Deputy Commissioner Dibrugarh is reproduced here and below as follows. You take the entire thing, okay? Page 37, Annexure G of WPC 6596 of 2021. This right, para. Just a moment. Four of the affidavit in opposition filed by the Deputy Commissioner Dibrugarh in WPC 3434 of 2022 is to the effect that all the petitioner's representations had been forwarded to the Superintendent of Police Sibsagar for information and necessary action. with a request to look into the matter of illegal selling and collection of fishery revenue by unauthorized persons. Full stop. The circle officer of the concerned revenue circle was also directed to take necessary action against illegal selling and collection of fish. Para 4 and 5, not 4, para 4 and 5. Next, the Superintendent of Police Dibrugarh, while letter dated 10/3, 10/3, what is this date? 10/3/2021, is it? Or 22? Page 75. Page 75.
The forwarding here, 11/9/14.
Huh?
Things by the authorities are 11/9 and 29, 10/3/21, 10/9/21. Therefore, 11
10/9
21.
21. No, cannot be. PAADCF. It's a 10/9/21. Addressed to the Deputy Commissioner Dibrugarh. That one representation we said was 15/1/21, no? That is 5/1/21, not 15/1/21. Earlier. There are 4 representations. The last one is 5/1/21. Okay. 5/1/21. Stated that to take necessary steps with regard to the petitioner's representation dated 5/1/2021, the following points needed to be ascertained. 1 and 2, at page 75 of 976.
Last.
Okay. The Joint Secretary to the Government of Assam, Fishery Department, thereafter wrote a letter dated 30/11/2021 to the Deputy Commissioner Dibrugarh, requesting him to cause a proper inquiry through the concerned revenue circle and police station to stop illegal collection. No, the revenue police station regarding the allegation of illegal collection of revenue. First up, if the allegation was found to be authentic, illegal collection. Now, the, no, this is a semi-comma. Follow-up action was to be taken to stop to stop illegal collection and to enable the petitioner to collect the sale proceeds of fish, which was the legitimate income of the petitioner society, so that they could deposit his money to the government regularly. To stop. 14. No, this is nothing.
This is a joint report, my lord.
How does it have anything to do with your allegation? This is not a question. It just says this is with regard to the area only. This has got nothing to do with the issue. As can be seen from the representations made by the petitioner and the report of the SP Sipsagar and letter written by the Joint Secretary to the Government of Assam Fishery Department, the issue pertains to the allegation made by the petitioner that he has not been able to collect a revenue from the sale proceeds of selling fish. It is not the case of the petitioner that the members of the petitioner society have been obstructed from fishing in the Dehing Part 1 fishery, just because some portion of the fishery lies within the area covered by the MAC. The representation submitted by the petitioner and the aforesaid report, the letters made by the state respondents could at best could at best be considered, that could at best give rise to an inference that some other persons other than members of the petitioner society have also been fishing in the Dehing Part 1 fishery and have not been giving any sale proceeds, not been giving any part of the sale proceeds as revenue to the petitioner who has been settled with the fishery. The area of the prayer of the petitioner for having the area of the fishery measured so that the area falling under the MAC should not be counted as part of the fishery settled with the petitioner for the purpose of recalculating the his money payable by the petitioner. Is not a relevant issue, and the prayer seems to have been made for reasons best known to the petitioner. The only issue is with regard to the apparent with regard to the alleged complaint by the petitioner that they have not been able to collect the revenue from 10 persons who are mentioned in their representations.
The ghats, the fish counters.
You have mentioned 10 persons in your,
No, we are
representation.
objecting. The ghats we cannot collect from the fish counters.
Mr. Council, I'll go only as per your.
No, as per the
representation.
document only, as per document. As per document.
No, I'm.
Page 36, the document that says, so.
Huh?
I'm not adding a word to it.
Page 36 of?
976.
Yes, so they're 10 persons.
No. May I read the paragraph? What is
Yeah.
the allegation? Respectfully stated that the government of Assam had settled the Hing Part 1 Fishery Beauty Cooperative Society from so and so 7 years as a regular settlement accordingly in our fishing selling centers, namely so and so 5 fish selling centers. We had gone for revenue collection. Some person from Missing Autonomous Council obstructed our fishery mohories.
Please continue reading.
As such, honor may be pleased to make it necessary actions against the below mentioned persons and facilitate our mohories to collection of revenue.
Please continue.
The humble prayer of Co Society, the names of the persons.
Huh? Name
10
the
persons.
persons. So they're 10 persons.
No, their fishing is not from the.
I do not know, Mr. Khan. I'm not going beyond that. Then what have I said? Full stop. Full stop. In view of the above facts, comma, this court is not inclined to pass any order. Where is that other order?
56, page 56 and 976.
Any order to page 56.
Page
Any
56
order
of
to
976.
to to measure the total area of the Dahing Part 1 fishery. Full stop. As the same is not an issue. As the same is not an issue in any of the writ petitions. The facts have been clearly can be clear. The facts in issue can clearly be seen from the petitioner's representations and the reports made by the state respondents, and any attempt to go beyond the issues raised in the representation would only cause confusion. And that can be seen from the various writ petitions filed by the petitioner in this case. Full stop. Full stop. Keeping all the issues, okay, now, in view of the fact that the issue pertains to the allegation made by the petitioner that the society has not been able to collect revenue due to the action of the 10 persons mentioned in the petitioner's representations, comma, the state respondents, comma, that is the state respondents, comma, that is the DC.
Fishery Department.
Huh?
Fishery Department.
The fishery department, comma, the DC and the DC Dibrugarh and the SP Dibrugarh or Sibsagar and the Dibrugarh shall cause an inquiry. No, shall make an attempt to conclude their investigation / inquiry with regard to whether the petitioner has been obstructed from collecting his revenue from fishing activities by the 10 persons and make a report.
No, not fishing activity, the collection of revenue, Lordship.
Yes, from the fishing activity, naturally, they cannot sell any other thing
Correct.
from the fishing from fishing activity. Okay, this is a fishing activity, say for collection of revenue from selling of fish, from selling of fish. Uh, at the earliest and preferably within a period of
2 months, 3 months, they are already the settlement.
within a period of 2 months. Within a period of 2 months. From the date of receipt of a certified copy of this order. The report made, the report on the inquiry made should be communicated to the petitioner.
All writ petitions accordingly disposed. Accordingly.
All the
sir,
writ petitions are accordingly disposed of. In the beginning, you write, all the writ petitions are being disposed of by this common order as the issue in all the writ petitions pertain to
More or less the same.
are more or less the same.
Let it be 3 months, or it will be not possible.
Okay, 3 months. I said preferably. I said preferably.
He's still Durga Puja time is calculated. I know.
Durga Puja is there.
Durga Puja.
Okay. Preferably within 3 months.
I'm so grateful, my lord.
Obviously.
I don't know. Let's see what happens now. They can, if they're not happy, they can go off.
No, no. There is no question of it. This is my
Well,
duty to place and
No, it's okay. Look, I don't feel bad. You're right. If you're right, you go for that. It doesn't make any difference whether you go, don't go, whatever.
Right.
I'm obliged.
Obliged.